영화 중에 종현이 이제밖에 없어. 예, 아니면 사회적인 이 메인 예, 한치라권 한치라권 누구랑 동기야? 그래서 아주 최근 최근 프로그램 네, 최근 원래
입니까? 마이크 테스트 중입니다. 네, 안녕하십니까. 잠시 안내 말씀드리겠습니다. 저희 오늘 행사장에 코로나 바이러스 확산 방지를 위해서 아크릴 비말 방지 가림막을 설치해 두었습니다. 끝부분이 다소 날카로우니 자리에서 이동하실 때 다치시지 않도록 유의하시기 바랍니다. 아울러 행사장 내에서 줌에 접속하실 경우 소리가 장내에서 울릴 수가 있으니 이용하시는 분들께서는 음소거를 반드시 해주시기를 바랍니다. 곧 글로벌 오션 레진 컨퍼런스 개회식을 진행할 예정입니다. 아직 로비에 계신 참가자분께서는 장내로 입장하시어 참석해 주시기 바랍니다. 그리고 동시 통역 서비스를 제공하고 있습니다. 한국어 채널은 1번, 영어 채널은 2번에 맞추어 사용해 주시기 바랍니다. For the online participants, please click globe-shaped icon for simultaneous interpretation. And before beginning, please do the final check of your webcam, now on connection, and microphone's condition. Thank you for your cooperation. 온라인에서 참석하시는 분들께서는 화면 하단에 지구본 모양의 통역 아이콘을 선택하시면 통역 언어를 선택하실 수 있습니다. Good morning, afternoon, and evening, ladies and gentlemen. Welcome to the 2020 Global Ocean Regime Conference. I'm Kim Ju-hyung from Korea Maritime Institute, and I'm deeply honored to be here with you this morning. Let me extend my sincere gratitude for joining us today at this virtual and international conference. This conference is sponsored by Ministry of Oceans and Fisheries and organized by Korea Maritime Institute. And we are lucky to have such a distinguished group of participants with us today. First, we will have opening remarks by President Jang Yong-tae of Korea Maritime Institute. Please welcome him with a round of applause.
Distinguished guests, good morning, good afternoon, and good evening. I'm Chang Yong-tae, President of the Korea Maritime Institute. I would like to start by extending my sincere gratitude to our distinguished guests for participating in the 2020 Global Ocean Regime Conference. Leading up to the 8th conference we are holding today, the GOLC has so far gathered experts of the law of the sea and maritime territory and established itself as a platform for discussing and exchanging views on marine-related issues. The 2020 GOLC has been faced with a new challenge presented by COVID-19, where only Korean experts are joining us in person here in Busan, and international experts are calling in from abroad via video conference. I would like to express my deepest appreciation to His Excellency, Mr. Moon Sung-hyuk, Minister of Oceans and Fisheries, for his unwavering support for hosting this academic conference. Chairman Kim Sung-jin of the Global Ocean Regime Forum for leading the GOLC, and Professor Donald Rothwell of the Australian National University, and Professor James Kraska of the US Naval War College for joining us online despite their very busy schedule. I would also like to thank Secretary General Michael Lutch of the International Seabed Authority, Judge Thomas Hyder of ITLOS, Professor Alfred Soons of the Utrecht University, Registrar Ximena Hinrichs OERs of ITLOS, Professor Ronan Long of World Maritime University, and Professor Aldo Cholkorp of Dalhousie University for sending us congratulatory remarks via pre-recorded video. On behalf of the organizers, I also extend my deepest gratitude to President Park Jin-hyun of ITLOS and experts from abroad who have prepared their presentation on video, and to Professor Park Yong-an member of the CLCS, Professor Kim Hyun-soo of Inha University, and all experts from Korea for joining us in person. I all send my words of gratitude and welcome to those of you calling in online. Distinguished guests, the topic of this year's conference is the role of the law of the sea and recent developments in global ocean governance. Maritime disputes between states have been on the rise. Recently, new maritime issues have been steadily emerging amidst the changing international maritime order. On top of conventional maritime disputes regarding maritime delimitation, fisheries, development of resources on the continental shelf, and threats to maritime security, new issues have continued to emerge on the marine environment and safety involving BBNJ and climate change, as well as on maritime application of cutting-edge science and technology. The key role and responsibility of finding a peaceful resolution and an appropriate response to these maritime disputes and issues are up to law of the sea experts. The special session prepared today will retrace the footsteps of major figures in the law of the sea who have wielded significant influence over building and global maritime order, starting with Hugo Grotius, who laid the foundation for international maritime order by formulating the mare liberum principle in the early 17th century, followed by others until the present time. This session will also serve as an important opportunity to discuss how a pool of law of the sea experts to be developed going forward. The KMI is the only specialized research institute on maritime policy under the Prime Minister's office and is pushing forward to build capacity in the law of the sea under a long-term plan. Prospectively, the KMI envisions to establish an independent institution that will conduct comprehensive research on marine norms, including the law of the sea. The necessary budget and staffing for next year have been secured for this endeavor. I also have plans to make steady investment in boosting capacity of our researchers in the law of the sea and to provide them with wide-ranging opportunities to engage in close exchanges with other law of the sea experts at home and abroad. One example is the KMI Global Research Fellow Program, where law of the sea scholars abroad are invited to Korea for minimum 1 month to engage in exchange and conduct joint research. I ask experts joining us via video conference at this time to take much interest in this program and share with us any advice that you may have. I expect this year's work to further highlight the important role of the law of the sea and maritime experts in establishing a peaceful maritime order and building a maritime governance in the future. I ask for your active participation in making this conference a success, and I once again thank all distinguished guests for your presence today. Last but not least, I hope we all surmount COVID-19 challenges, and I would like to conclude by wishing you good health and good luck. Thank you.
Thank you. The following is a welcoming remarks by Mr. Moon Sung-hyuk, Minister of Oceans and Fisheries. Please wait just a second.
여러분 반갑습니다. 해양수산부 장관입니다.
잠시만요. 저 지배인님 포디움 좀 치워주십시오. 네, 다시 진행하겠습니다. 비디오 부탁드립니다.
여러분 반갑습니다. 해양수산부 장관입니다. 제8회 글로벌 오션 레지임 컨퍼런스 개최를 진심으로 축하드립니다. 코로나19로 어려운 상황에서도 행사를 준비하고 참여해 주신 모든 분들께 감사의 말씀을 드립니다. 올해로 8번째를 맞이한 글로벌 오션 레지임 컨퍼런스는 그간 국제해양법의 다양한 현안들을 논의하면서 평화적인 국제해양 질서 모색에 크게 기여하여 왔습니다. 그러나 여전히 전 세계 바다에선 경쟁과 갈등이 계속되고 있고 무인 해양과학조사, 자율운항 선박 등 해양법 협약 체결 당시에는 미처 생각하지 못했던 새로운 이슈도 속속 등장하고 있습니다. 이번 국제해양 거버넌스에서 해양법의 역할과 발전이라는 주제가 그 어느 때보다 큰 의미로 다가오는 이유이기도 합니다. 오늘 컨퍼런스가 주요 해양법 이슈의 최근 동향을 살펴보고 변화하는 환경에서 해양법의 역할에 대한 고민을 통해 새로운 해양 거버넌스를 찾아가는 뜻깊은 자리가 되길 기대합니다. 이러한 우리의 노력은 갈등과 자국 우선주의를 넘어 평화의 바다를 정착시키는 밑거름이 될 것입니다. 해양수산부도 안정적인 국제해양 질서의 정착을 지원하기 위해 국제법 전문가 양성과 해양법 전문 연구기관 설립에 적극 앞장서겠습니다. 알찬 발표와 토론을 기대하며 참석하신 모든 분들의 건강과 행복을 기원합니다. 감사합니다.
Unfortunately, today he was not able to join us this conference due to the schedule on assembly. Although he could not make his tour to here today, he kindly sent us the video message for us. And please give him a big round of applause. Thank you. This time, we are going to watch congratulatory video messages delivered by distinguished guests who are Mr. Michael Lodge, Secretary General of the International Seabed Authority, Mr. Thomas Haida, Judge of the International Tribunal for the Law of the Sea, Professor Alfredo Suns of Utrecht University, Ms. Ximena Heinrich Oyars, Registrar of ITLOS, Professor Ronan Long of World Maritime University, and Professor Aldo Cherkov of Dalhousie University. Let's watch the videos. 축사 영상 부탁드립니다.
Distinguished colleagues, ladies and gentlemen, greetings from the International Seabed Authority in Jamaica. It is a pleasure and an honor to deliver this short message on the occasion of the 2020 Global Ocean Regime Conference. I congratulate the Korea Maritime Institute and the Ministry of Oceans and Fisheries for organizing this conference and enabling these important discussions to take place online. I had the pleasure of attending this conference in the past, and I'm sorry that I'm not able to be with you this year. Looking at the level of expertise represented over the next 2 days and in the different sessions, I am confident that the conference will produce insightful suggestions and recommendations. Considering the status of the law of the sea and global ocean governance today, it is more important than ever to engage with one another in open dialogue and exchange of views. It is good to see that the agenda places special emphasis, therefore, on the role of experts in the law of the sea and their engagement with issues of global ocean governance. I firmly believe that the key to ensuring sustainable management of marine resources, whether living or non-living, for our common benefit, is the consistent and uniform implementation of international law as reflected in the UN Convention on the Law of the Sea. I wish you well in your deliberations. I look forward to the outcomes of the conference, and I look forward to joining you in person at a subsequent event. Thank you very much.
Dear participants, as a long-time collaborator of the Korea Maritime Institute, it gives me great pleasure to send you my greetings at the opening of the 2020 Global Ocean Regime Conference in Busan. The conference, which is of course by necessity virtual this year, is entitled The Role of the Law of the Sea and Recent Developments in Global Ocean Governance. I note that the program includes prominent legal and scientific experts, many of whom I know personally, and some of my favorite topics, such as the outer continental shelf and fisheries. I also note with great pleasure that my friend and colleague, President Peck, will give a keynote speech. This is probably among the last, if not the last, public statement he will make in that capacity, as his presidency is coming to an end. President Peck has for the last 3 years performed his functions with excellence. And this year has been particularly challenging. Koreans have every reason to be very proud of him. I hope you will all, wherever you are, enjoy and benefit from this very interesting conference. And I hope to see you all in person as soon as possible.
Good morning, ladies and gentlemen in Busan, and good afternoon or good evening to the participants in other parts of the world. Greetings from the Netherlands. I regret that I cannot be with you in Busan to attend the interesting program on your, the interesting panels on your program, but I look forward to watching the recorded sessions, and I'm sure I will enjoy the presentations and the commentaries. Congratulations to the Korean Maritime Institute for again organizing this conference. I wish you all 2 great days, and I hope to see you next year.
Good morning and greetings from the seat of the International Tribunal for the Law of the Sea in Hamburg. In challenging times like the present, when states are inevitably looking inwards, it is important not to lose the global context and to pursue discussions relating to global ocean governance. I commend, therefore, the Korea Maritime Institute and the Ministry of Oceans and Fisheries of the Republic of Korea for organizing this event. I wish the Global Ocean Regime Conference participants a stimulating and successful conference.
Good morning from the World Maritime University in Sweden. My name is Ronan Long, and I'm the director of the university's Global Ocean Institute. It is a great honor and privilege to join my dear friend and former colleague, distinguished Professor Daniel Moon, Minister of Fisheries and Oceans of Korea, and the KMI President, as well as the distinguished moderators, speakers, and conference participants. I wish to convey the congratulations of the President of the University on the organization of this wonderful conference program. And we wish you every success and very much look forward to being with you in person in Busan or indeed here in Sweden for future events. Thank you very much.
Good day to all participants of the 2020 Global Ocean Regime Conference. on the role of the law of the sea and recent developments in global ocean governance. As a former participant of this very successful conference series, I'm very pleased to offer greetings and good wishes from Canada. As in the past, the conference brings together leading academics to exchange views and ideas on major contemporary issues in the law of the sea. However, this year the conference is different from others in the past. Kudos to the Korea Maritime Institute and the organizers for convening this conference at a time when it is especially difficult to convene international high-profile meetings because of the continuing pandemic challenges. So congratulations to the Korea Maritime Institute and the Ministry of Oceans and Fisheries for continuing this successful conference series.
Thank you. Now we will have a group photo session here. 장내에 계시는 참석자분께서는 앞으로 나와 주십시오. And online participants, please stay so that we can take picture with you. 온라인에 계신 분들께서도 웹캠에 그대로 남아주시기 바랍니다. 저희가 같이 단체 사진을 찍도록 하겠습니다. 네, 저기 이쪽으로 네, 이쪽으로 오시면 돼요. 저희가 단체 사진 찍겠거나. 네,
마스크 쓰고 해야 되나?
온라인에 계신 분들께서도 웹캠으로 사진 촬영에 참여하실 수 있습니다. To online participants, please stay so that we can take picture with you. Thank you. And that completes the opening ceremony of 2020 Global Ocean Raising Conference. We will continue the next program after 10-minute break for preparing sessions. 감사합니다. 네, 팀장님, 저희 시간 있습니다. 네, 회의 진행하도록 하겠습니다. The following is a keynote address by President Baek Jin-hyun of International Tribunal for the Law of the Sea. 장내에서 줌을 이용하시는 분께서는 음소거 부탁드립니다. Unfortunately, he could not join us today as well. So we are going to watch video that he prepared for us. Please welcome him with a big round of applause.
Good morning, dear colleagues. I'm pleased to make a keynote speech in the virtual conference hosted by the Korea Maritime Institute in cooperation with the Ministry of Oceans and Fisheries of Korea. I understand that organizing today's conference has not been easy, to say the least, under the current circumstances. I therefore wish to congratulate the organizers for being able to pull this event off in these challenging times. The law of the sea plays a crucial role in global ocean governance, and its role is increasing. In particular, the United Nations Convention on the Law of the Sea has been instrumental in promoting the rule of law in the global oceans. The convention has achieved near universality with 168 states parties so far. Since its entry into force 26 years ago, the 2 additional implementing agreements have been adopted, and the 3rd is currently under negotiation. The UNCLOS regime as a whole has been stable, yet flexible enough to accommodate any necessary change, and I believe is at the heart of the global ocean governance. Indeed, it is difficult to think of global ocean governance without the effective UNCLOS regime. Dear colleagues, we are now in the midst of COVID-19 pandemic, which is affecting the entire world. There is virtually nothing that is free from the impact of the pandemic. International adjudication is no exception. Indeed, the pandemic has posed serious challenge to international courts and tribunals in the performance of their essential function. As you know, international judicial institutions were established to deal with international disputes. As such, they hold various meetings, such as hearings, judicial deliberations, administrative and organizational meetings, and consultation of many kinds at their seats around the year. These meetings are attended by judges, representatives of the parties, such as agents, counsel, and advocates, others involved in the proceedings, including experts or witnesses, and staff members in wide-ranging capacities to support judicial works. The participants come from all over the world, and their smooth and unimpeded travel to and from the seats of judicial institutions is sine qua non of their effective functionings. This is how international adjudication operates. However, the pandemic and resulting restrictions have upended the basic premise of the operation of international adjudication. Today, I wish to take this opportunity to share with you how the COVID-19 pandemic has affected the works of International Tribunal for the Law of the Sea, and how the Tribunal has coped with this unprecedented challenge. Before doing so, however, let me briefly review how the pandemic has affected international adjudication in general by taking a quick look at the situation of some other international judicial institutions. First, the International Court of Justice. The ICJ, in its initial response to the COVID-19 pandemic, announced that there would be no hearings of the court until at least 16 April 2020. This period was subsequently extended to the end of May. The ICJ also had to postpone the planned hearing in some cases. On 25th June 2020, the ICJ announced that it had amended the rules of the court regarding hearings and the readings of judgments. These amendments allowed the court, for health, security, or other compelling reasons, to hold the hearing entirely or in part by video link and to read the judgment at a sitting of the court accessible to the parties and the public by video link. On 30 June 2020, the ICJ held, for the first time in its history, a virtual public hearing on the question of the court jurisdiction in the case concerning arbitral award of 3rd October 1899 between Guyana and Venezuela. The hearing took place with physical presence of some members of the court, with other members participating using video conferencing technology. A few other virtual or hybrid hearings have subsequently followed. For example, from 31st August to 7 September 2020, the hearings were held in case concerning application of the International Convention on the elimination of all forms of racial discrimination between Qatar and United Arab Emirates. International Criminal Court. On 23rd June 2020, the Presidency of the International Criminal Court published guidelines for the judiciary concerning the holding of court hearings during the COVID-19 pandemic. The guidelines provide that each chamber may determine whether to hold a physical hearing, a remote hearing facilitated through the use of communication technology not requiring physical presence in a courtroom, or a combination thereof. From 22nd to 24 June 2020, the Appeals Chamber of the ICC held a partially virtual hearing. A few other such hearings have followed. Permanent Court of Arbitration. A representative of the PCA has stated that the PCA has successfully held several online arbitral hearings, primarily using the Zoom video conferencing platform. For example, on 12 and 13 June 2020, the PCA held public hearings by video conference on preliminary objection and bifurcation in the case the Renko Group Incorporation versus Republic of Peru. Few other such hearings have followed. Dear colleagues, now let me turn to how the tribunal has so far coped with the challenges arising from the COVID-19 pandemic. The first impact of the pandemic was felt in relation to the previous administrative session of the tribunal. As you may know, tribunal each year holds two such sessions, one in spring and the other in autumn, devoted to legal and judicial as well as administrative and organizational issues. The 49th session, which took place in the middle of March this year, had to be shortened in light of the COVID-19 pandemic. During the session, many states began to close their borders, and it became difficult for some members of the tribunal to return to their home countries. As the spread of the virus progressed and the situation became increasingly serious in Germany and elsewhere in the world, I decided to restrict the number of staff working at the tribunal's premises. From 23rd March until 18 May, the majority of the registry staff worked remotely, while some staff members remained present at the premises in order to ensure essential functions. During this time, the registry coordinated its work through tele and video conferencing technology. Most staff members have now returned to work at the premises of the tribunal, while health and safety procedures are in place to prevent the spread of the virus. Visits to the tribunal remain restricted until further notice. As concerns its judicial work, the tribunal currently has 2 pending cases on its docket. Dispute concerning delimitation of the maritime boundary between Mauritius and Maldives in the Indian Ocean, and the MT San Padre Pio No. 2 case between Switzerland and Nigeria. In the latter, we are currently at the written phase, and the applicant's memorial has been submitted in accordance with the time limits fixed. To date, the COVID-19 pandemic has not had any visible impact on proceedings in that case. In contrast, the pandemic has affected proceedings in the dispute between Mauritius and Maldives. The dispute was submitted to a special chamber of the tribunal composed of 9 judges by special agreement of the parties. On 18 December 2019, Maldives had filed written preliminary objections to the jurisdiction of special chamber and the admissibility of Mauritius claims. In my capacity as president of the special chamber, I held consultation with the representatives of the parties on 4 February this year to ascertain their views with regard to the question of procedure. During this consultation, the parties agreed that the hearing should take place from 24 to 27 June 2020. However, in light of the situation concerning the pandemic and the resulting containment measures, it was considered unrealistic to hold the hearing on the days previously agreed. During further consultations, the parties agreed that the hearing should be postponed to the week of 12 October 2020. While the postponement of the hearing was made in the expectation that it would take place with the physical presence of all participants at the seat of the tribunal in Hamburg, the pandemic situation continued to be uncertain, and it remained likely that travel and other restrictions might prevent at least some of the participants from taking part in the hearing in person. The special chamber thus had to explore options for remote participation in hearing. This also applied to the 50th administrative session of the tribunal, which was expected to begin late this month. Eventually, the tribunal and its special chamber have decided to hold the hearing and judicial deliberations, as well as the 50th session in a virtual or hybrid format, in which some participants take part in person and others remotely. It was obviously unprecedented unprecedented decision, as neither the tribunal nor any of its chambers has previously held virtual or hybrid hearings in any of the cases pending before them. In reaching these decisions, the tribunal had to consider several legal, administrative, technical, and practical issues. Let me now turn to some of them briefly. Perhaps the first and the most important issue concerns the question as to whether, under the current rules of the tribunal, a virtual or hybrid hearing can be held at all. The hearing is an essential part of the proceeding before the tribunal. There are several provisions in the rules on the conduct of the hearings. However, neither the statute nor the rules explicitly address the question as to whether a hearing can be held by way of video conference. It may be noted that rules appear to be predicated on the assumption that, in principle, the hearing, and in fact all meetings of the tribunal for this matter, takes place in person at the seat of the tribunal in Hamburg. Clearly, at the time when the rules were drafted, virtual hearings were not foreseen, partly because the technology to allow for remote participation was not widely available at that time. However, this does not necessarily mean that the rules exclude such possibility, particularly if an evolutionary interpretation of the term hearing or meeting is applied. It is true that virtual hearings may differ from traditional concept of hearing, which requires the physical presence of all relevant actors in one place. However, I think that the principal function of the hearing, namely to provide an opportunity for direct confrontation of the parties in open court, can be fulfilled without the physical presence of all actors. The key aspect of the hearing is the direct exchange of argument between the parties. And with the help of modern video conference technology, this seems to be possible in a virtual or partial virtual courtroom. Public access to the hearing. Pursuant to Article 26, paragraph 2 of the statute and Article 74 of the rules, hearing before the tribunal are in principle open to the public. Public access is a fundamental feature of proceedings before standing international courts and tribunals, and has been referred to in legal literature as one of the features distinguishing the judicial settlement of international dispute from settlement through arbitration. However, the pandemic has made it necessary to restrict physical access to the courtroom of the tribunal. In such an event, public access to virtual hearing would be provided by live stream of the hearing available on the internet, or if a live stream were unavailable, a webcast. Procedural equality. Though not explicitly referred to in the rules, the principle of procedural equality between the contending parties in the course of judicial proceedings may be considered to constitute a general principle of international law, applicable in proceedings before the tribunal. Accordingly, when a hearing takes place in virtual or hybrid format, both parties must be given an equal opportunity to present their arguments, either in person in the courtroom or via video link. In addition, care must be taken to ensure that there should be no difference of treatment between the two modes of participation. Reading of judgment. The rules of the tribunal provide that the judgment of the tribunal or advisory opinion of the seabed dispute chamber shall be read at a public sitting. Therefore, the tribunal may have to consider whether a webcast of reading of judgment or advisory opinion would satisfy the requirement of reading at a public sitting. Secrecy of deliberations. Article 42, paragraph 1 of the rules requires that the deliberation of the tribunal shall take place in private and remain secret. Accordingly, it would be necessary for any electronic platform used for virtual deliberation to ensure that their full confidentiality. Decision making. Pursuant to Article 9 of the resolution on the internal practice of the tribunal, the vote on a judgment or decision is cast in person by an affirmative or a negative vote. This article also provides that in exceptional circumstances, the tribunal can accept that an absent judge may vote by appropriate means of communication. Thus, Article 9 of the resolution would allow for voting on an order or judgment by electronic means of communication, including through video conferencing. However, when secret voting is needed, as in elections, the secure online system must be devised to ensure secrecy. Technical issues. The holding of virtual hearings also raises several technical challenges. For example, all speeches and statements made and testimonies given at the hearing or meetings in one of the official language of the tribunal have to be simultaneously interpreted into the other official language. Therefore, the tribunal must identify and install software that allows for video conferencing with simultaneous interpretation. For the conduct of virtual deliberations, it would be necessary, as I mentioned, to use specific video conferencing software that fulfills the requirements of the tribunal. Such software must allow for a secure and private connection of all participants. The location of relevant parties and participants in different time zones around the world can also raise practical issues. This would require the tribunal to adjust the timing and duration of the hearings or meeting so that strict procedural equality can be ensured. Dear colleagues, as I have outlined, the ongoing pandemic poses various challenges to international adjudication and the work of the tribunal. However, I do not think they are insurmountable. I'm confident that various difficulties I mentioned can be overcome with creativity and that tribunal will continue to operate effectively and discharge its responsibilities despite wide-ranging restrictions in place to cope with the threat of the pandemic. In addition, COVID-19 restrictions are likely to bring about further innovation in the way tribunal fulfills its mandate, allowing the tribunal to deal expeditiously with the cases currently pending before it, as well as any new cases that may be submitted. In this regard, I may inform you that the tribunal will shortly consider amending the relevant provision of its rules to avoid any uncertainty or controversy about the new format of hearing or meetings. This brings me to the end of my speech. In closing, I want to take this opportunity to express, on behalf of the Tribunal, my sincere appreciation to the Korea Maritime Institute for its financial assistance for the capacity building activities of the Tribunal over the past several years. KMI's support has been important and indispensable to our internship program and ITLOS regional workshop, from which I believe the next generation of the law of sea experts has greatly benefited. Thank you very much for your kind attention.
Thank you. Now we are going to commence special session. Speakers and discussants of special session, please move to the seat on the floor. This special session will be discussing about role of the law of the sea and role of its experts in global ocean governance. Moderator of this session is Dr. Kim Hyun-soo, professor of Inha University. And the speakers are Professor Australian National University, Donald Roswell, and Professor James Kraska of U.S. Naval War College, and Professor Lee Geun-kwan of Seoul National University. And discussants are Research Fellow of KMI, Dr. Kim Du-young, and Vice Chairman of Korea Council of Foreign Relations, Dr. Lee So-hang, and International Cooperation Officer of Coast Guard, Mr. Kim Yong-jin. Professor Kim, the floor is yours.
Can you hear me? Okay, thank you. Good morning again. My name is Kim Hyun-soo, currently working at Inha University Law School. I'm so honored to moderate this special session, and especially I would like to thank you to President of KMI, Dr. Jang Yong-tae, for his kind invitation to me for this special conference. As you know, we are facing so many international ocean matters, such as piracy, terrorism, climate change, Arctic issue, marine pollution, sea level rising, freedom of navigation, maritime boundary, sovereignty of islands. So many issues are to be concerned with all of us. So today, we particularly KMI set up the special session titled "The Roles of the Law of the Sea and Its Experts on Ocean Governance," and such a wonderful topic. So today, I would like to introduce three distinguished speakers. First one is Professor Roswell from Australian National University. And second, Professor Kraska from U.S. Naval War College. And final speaker will be Professor Lee Geun-kwan from Seoul National University of Korea. We have tight schedule today, so please, all speakers, panelists, keep the time limit. And I'll give it just 24 minutes to presenters and 5 or 7 minutes to the panelists, please. And now I'd like to invite the first speaker, Professor Roswell, and he already sent us a recorded tape on Law of the Sea scholars from Grotius to today, global, regional, and national influence and impact. So I'd like to invite him through the video tape, and watch the video tape. I will continue to the next stage. And please watch the tape.
Well, hello, everyone. It's a great pleasure to be able to join you at this conference today. My apologies for being unable to attend in person, but I think we all appreciate the reasons for that. So today I'm going to introduce this session by looking at Law of the Sea scholars from Grotius to today, thinking about their global, regional and national influence and impact. And I'm going to make some particular remarks from an Australian perspective towards the end of my presentation, which is what I've been asked to give some attention to today. So first of all, one can't really commence a discussion on this subject matter without discussing Hugo Grotius, the Dutch scholar whose influence upon international law and indeed the law of the sea is absolutely critical. I won't say anything more about Grotius because I'm sure that he's very familiar to you, but Professor Kraska will be elaborating more on Grotius in his session that follows immediately after. But Grotius, of course, wrote from a distinctively Dutch perspective at the time and very much favoured the notion of open seas or the freedom of the seas. And of course, those are principles that we still associate today with provisions in the 1982 UN Convention on the Law of the Sea. But one of the interesting aspects about the work of Grotius was that it created opportunities for other scholars to respond. And we saw in the early part of the 17th century a period which often is referred to as the Battle of the Books. And that is that there were alternate views put to those promoted by Grotius. And these scholars were mostly scholars from what we now know as the United Kingdom, Selden from England and Wellwood from Scotland, who promoted views in which the seas or the oceans could be closed or the oceans could be subject to some level of appropriation and control. Now, of course, those views were not ones that prevailed at the time, and the Grotian view of the oceans became the dominant one, but it immediately identifies to us the significance of the role of scholars in promoting the development of the law of the sea, even back in these very, very early years of the development of the discipline. If we move forward into the 18th century, Van Binkershok's work was influential in terms of actually beginning to suggest that coastal states did have certain entitlements over at least the narrow belt of waters adjacent to their coastline. And of course, Van Binkershok's work is often credited with promoting the development of the so-called cannon shot rule, which we very much associate with the territorial sea and with the breadth of the territorial sea being one which gives to a coastal state an entitlement over an area of approximately 3 nautical miles. But this once again emphasises the importance of scholars in these very early formative years. Now, I'm not trying to, in this presentation, give you a detailed historical overview, but rather more of a snapshot in terms of an appreciation of the pivotal role that scholars have played in the development of the law of the sea in the early centuries. If we move forward into the 20th century, we're now moving beyond a period where a lot of foundational works outlining key theories, key principles, key concepts were promoted with respect to the law of the sea. And we're now moving more into a period where, of course, we have much more state practice to think about. We have much more customary international law beginning to develop in areas such as the notion of the high seas, questions with respect to piracy, and of course, reflections of the legitimacy of the rights of coastal states to be able to claim a territorial sea. So the works that I've listed here are ones that are just an illustration of some of the works that appeared in the period up to World War II, a range of scholars promoting a variety of views, but increasingly, of course, these scholars were promoting views that ran counter to the core principles that Grotius was certainly promoting. So to that end, scholarly debate and discussion was critical, but it was also, of course, reflecting principles of state practice in terms of recognising the ability of states to be able to legitimately exercise sovereignty and aspects of jurisdiction over the oceans. There was also a strong interest in this field, and I think that's reflected in the fact that the book by Columbus, The International Law of the Sea, first published in 1943, ultimately ran to 11 editions, with the last edition appearing in the 1960s. Of course, this all ran up to the period which we celebrate as Law of the Sea scholars, with the development of the first United Nations Conference on the Law of the Sea in 1958. And to that end, it's important to note the pivotal work, I would suggest to you, of McDougall and Burke, published in 1962 following the conclusion of that first UN conference, which looked much broader at the public order of the oceans and took a much more comprehensive perspective in terms of the way in which we should look at international legal frameworks governing oceans governance effectively. The other important point to note is, of course, the role played by scholarly associations during the 20th century. And so the initial work of bodies like the International Law Association, the Institut de Droit International, and the Harvard Research Group are all critical in terms of some of those foundational works that were done to try to consolidate and think about the way in which the law of the sea could ultimately be reflected in emerging international treaty frameworks. Now, of course, a major turning point in all of this arose with the work of the International Law Commission, in particular the work of the ILC during the 1950s, where it was tasked to look at key aspects of the law of the sea, in particular the high seas, the territorial sea, and the continental shelf. To that end, the work of Francois, the rapporteur, the special rapporteur of the International Law Commission, was critical. The debates within the Commission are critical. Of course, the Commission includes members drawn from international jurists, but also international legal scholars. And so to that end, scholars were making a significant contribution to the work of the Commission during those critical formative years of the 1950s. And the ILC, of course, is continuing to look at law of the sea related questions, given the fact that it's currently looking at questions on sea level rise in relation to international law. If we move to think then in terms of the current period leading up to the conclusion of the convention, and then now the period that the convention has been in force, numerous scholars played important roles on national delegations during the negotiation of the convention during the 1970s, running through till 1982. And many of those scholars transitioned into becoming leading experts on the law of the sea, or quite separately gained skills in assessing, educating and writing about the law of the sea in the 1980s and 1990s. And so the role of scholars as educators about this new global body of international law, which we call the law of the sea, also needs to be acknowledged, especially during those periods when states were becoming accustomed to understanding the convention, a very large convention of 320 articles, which had significant ramifications for many, many states across multiple different areas. And of course, there was also an opportunity for scholars to play a role at the International Tribunal for the Law of the Sea once the tribunal was established under the framework of the convention. And to that end, the role of Professor Park from Korea needs to be acknowledged, but also scholar practitioners, jurists like Rutger Wolfram, who sat on the tribunal for many, many years, needs to be also acknowledged. And of course, many of those scholars at ITLOS also played roles as arbitrators in international arbitrations established under Annex 7 of the Convention. And even scholars who were appointed to the International Court of Justice played a significant role in terms of developing aspects of the law of the sea. And here Judge Oda, who wrote quite extensively on aspects of the law of the sea prior to his election to the International Court, needs to be acknowledged. So in more modern times, we can think of a range of texts and monographs which have had significant impact upon the way in which students have learned about the law of the sea, an impact upon practitioners in the law of the sea, and have also inevitably had some impact upon international courts and tribunals. So one of the most influential works for me was that prepared by Dan O'Connell, an Australian who originally came from New Zealand, and that work of his, The International Law of the Sea, published in 2 volumes in the early 1980s, was really a foundational body of consolidated work on the law of the sea and crossed the divide between pre-UNCLOS thinking of the law of the sea and post-UNCLOS thinking. Churchill and Lowe, of course, is one of the standard works in the area, and it was my privilege a few years ago to be involved with a number of colleagues in completing the Oxford Handbook of the Law of the Sea, which is a consolidated collection of work by many leading scholars, but also some jurists looking at a range of traditional but contemporary law of the sea questions. We can also think of the role that scholars have had within regions, and within East Asia and Southeast Asia, I think we can reflect upon the role that bodies like CEPOL, the Southeast Asian Program in International Law, had during the 1980s and 1990s, of which Douglas Johnson and our good friend and colleague Ted McDorman played pivotal roles. The Centre for International Law at National University in Singapore, long associated with Bob Beckman, who I'm sure is also known to many of you, also indicates the significant role that scholarly research-focused bodies have had on the development, education and understanding of aspects of the law of the sea. And even more recently, the USO Academy of the Law of the Sea, which I've had the privilege to be involved in, is another good example of a body in which a number of scholars are engaged as instructors in that program, are able to advance knowledge and understanding of aspects of the law of the sea. So particularly thinking about these issues from an Australian perspective, I'm just wanting to highlight a number of my colleagues who paved the way for an understanding of the law of the sea, not only within Australia, but also regionally and also globally. Dan O'Connell I've also referred to, Professor Ivan Shearer, of course, who edited O'Connell's work and was an ad hoc judge at ITLOS and also on Annex 7 arbitral tribunals. Professor Gillian Triggs's work on Antarctica and the law of the sea, very significant. And of course, Professor Sam Bateman from ANCORS at the University of Wollongong. All of these colleagues, Australian colleagues, have been very influential in terms of not only as educators, but also as scholars developing our thinking and understanding of various aspects of the law of the sea. So turning to my concluding remarks, hopefully it's clear that throughout this presentation, I've been trying to emphasise that a critical aspect of the development of the law of the sea has been the role played by scholars. And we very much think about that if we trace this lineage running from the work of Grotius even through to the current day. And I would suggest to you that that's a very distinctive aspect of the law of the sea compared to some other disciplines in international law. But then to particularly think about the role of Australian scholars from a very parochial Australian perspective, why is it that Australian scholars have had the opportunity to gain prominence in terms of certain aspects of the law of the sea? Well, predominantly I think they've got a solid legal education in Australia, but that legal education has been boosted through doctoral study, predominantly in the United Kingdom, the United States, and sometimes in Europe. And as a result of that work, they've been able to publish monographs with leading international law presses, which has allowed their work to gain prominence and assisted in terms of an understanding of their perspectives and also measures of esteem in terms of associated aspects of how they've sought to develop their arguments in terms of some of these critical issues for the law of the sea. Australian scholars, of course, have the advantage of being able to focus on multiple international law of the sea questions associated with Australia, but they haven't only focused on law of the sea issues associated with Australia, and I think that's an important point. They've looked at a range of questions that not only impact upon Australia, but impact upon countries globally. So yes, they have an Australian perspective, but they do not have an Australian-only perspective, and I think that's an important dimension in terms of the perspective that they've brought to bear on these issues. Their research has predominantly been supported by Australian government funding, which has helped a great deal. They've also undertaken vast amounts of international travel to attend conferences in various parts of the world, which is critical if one lives in Australia and is seeking to work in this field of international law. And then finally, I think that many of these Australian scholars, including myself, have drawn inspiration from the senior scholars and practitioners of international law that I've spoken about that have come before us. So thank you very much for that, and I look forward to the discussion and Q&A which will follow.
Okay, thank you, Professor Rosser, for your best research work and presentation. He just broadly touched upon the how the scholars and research institution play the role.
On the role of the law of the sea and its
just wait a second. Okay, I'm going to move to next speaker. Professor Kraska is waiting for us to make a speech, and he also sent us recorded tape on Law of the Sea practitioners from Grotius to today, global, regional, and national influence and impact. And also, I'd like to invite him through the tape. And, please watch the tape from the Professor Kraska. Are you ready to watch the videotape?
Hello and welcome to the special session on the role of the law of the sea and its experts in global ocean governance. I'm James Kraska from the Stockton Center for International Law at the U.S. Naval War College, and I'm going to talk about the law of the sea practitioners from Grotius to today. And in particular, I'd like to focus on 3 practitioners that were instrumental in creating key concepts and doctrine in the law of the sea. That is, Hugo Grotius, Franklin Delano Roosevelt, and Arvid Pardo. These gentlemen, spanning the centuries, developed the concepts of freedom of navigation, the continental shelf and the exclusive economic zone, or more accurately, a fishery zone, fishery conservation zone, and the common heritage of mankind in the international deep seabed area. These 3 towering figures of the law of the sea created the foundation that we still stand on. Hugo Grotius, the father of international law, in the early 17th century created the doctrine of freedom of the seas. President Franklin Roosevelt created the concept of the continental shelf. Also the work on the first fishery conservation zone, the predecessor to the exclusive economic zone. His continental shelf idea gained instant customary law status when he converted a geophysical term of the continental margin into a legal term imbued with coastal state sovereign rights and jurisdiction. And Arvid Pardo, mid-20th century diplomat who championed the idea of a shared destiny and a common heritage of mankind beyond national jurisdiction. In each case, these 3 men were not necessarily the first people to articulate the legal doctrines for which they're known. In the case of FDR, it's actually President Truman that is credited with signing the fishery conservation zone and the proclamation on the continental shelf. But they were developed by Roosevelt. And these 3 men advanced through the rule of law the tangible expression of state practice, not as theory, but as practical rules for international relations and governance in a global system. It's no surprise then that the first of our figures, Hugo Grotius, arose within the context of a global conflict that spread throughout the world from a revolt in the Dutch Republic, but implicated the Spanish Empire and the Portuguese Empire. And during this conflict, the case that Hugo Grotius became famous for, the seizure of the Santa Catarina, occurred in distant Malacca, halfway around the world. So how did Hugo Grotius get involved in this? It's because in this case, he was a Dutchman who was in the country at the time of the Dutch War of Independence from 1568 to 1648. And although the Dutch republics were fighting a war of independence against Spain, that conflict also implicated Portugal, because Portugal had joined with Spain in the Iberian Union. So the Portuguese vessel Santa Catarina was seized near Singapore, and this carrack was heavily laden with valuables from the East, hundreds of ounces of musk and Ming porcelain from China. And the vessel was brought back to Amsterdam Admiralty Court and adjudicated as a lawful prize, a seizure in the law of naval warfare. And the case was decided in favor of the Dutch East India Company, and Hugo Grotius wrote the legal brief for the company called Mare Liberum, or the Free Sea. And this brief convinced the court that it was a lawful seizure, that this vessel was a lawful prize, even though Portugal claimed to have ownership over this area. Grotius's concept of the free sea entered into customary international law. Our next figure, President Roosevelt, acted in a number of important ways to somewhat restrict that freedom of navigation. His first act was to join with the Organization of American States in 1939 and adopt the Panama Declaration. The Panama Declaration stated that no belligerents could conduct belligerent activity, the Europeans, inside this zone that stretched 200 to 300 miles off the coast of North and South America. The Panama Declaration reflected President Roosevelt's tendency to assert American jurisdiction far out into the ocean. During the same time, he was working on a similar proposal with regard to the continental shelf. The continental shelf had two dimensions in American legal thinking. The first is that it was a federalist issue in which the individual states were making their own individual claims for the seabed resources, and the states were suggesting that they had the power to tax offshore oil and gas. There was also the international dimension of the United States vis-a-vis other countries. And President Roosevelt was keen to expand U.S. jurisdiction, the jurisdiction of the federal government, both to restrain the states as well as to inform other countries. President Roosevelt did not live to see his policy implemented. It was announced actually by President Truman. President Truman was sworn in on April 12, 1945, and he announced the famous proclamation on the continental shelf just months later, in September 28th of the same year. And in the Truman Proclamation, the United States claimed exclusive rights to the resources of the seabed to a depth of about 200 meters. And states followed this American precedent and began to declare their own continental shelves, and indeed use it as a springboard for even greater maritime claims. The United States said that the continental shelf was subject to its jurisdiction and control, and that this was reasonable and just because it could be considered, the continental shelf could be considered an extension of the landmass of the coastal state. Just as President Roosevelt was looking to the continental shelf to provide resources, mineral resources for the US economy, he also was very sensitive to US conservation of living resources. As early as the 1930s, the United States became concerned about Japanese fishing vessels in the Bay of Bristol, Alaska. These ships were fishing beyond the 3-mile territorial sea, and US industry, the influential Salmon Lobby, and the Fishing Union sought governmental protection. And throughout the 1930s, the United States considered legislation or unilateral proclamation to claim some sort of jurisdiction over the salmon fisheries in this area and to keep Japanese fishing vessels away. The United States proposed a regional agreement with Japan and the Soviet Union, but this was also opposed by the labor unions and the salmon fisheries of the West Coast. And Japan demurred at the time because, after all, it had a right to fish as part of its high seas freedom. This controversy also emerged within the backdrop of Japan and US foreign policy and Imperial Japan's role in East Asia. And so relations increasingly were strained as the states marched toward World War II. Japan was unwilling to permit US inspectors on their fishing vessels, but it did agree in 1938 to a temporary suspension of new licenses for its fishing vessels. But this was not a permanent agreement. It was only a temporary resolution. The Roosevelt administration continued to consider and work on how to protect the living resources offshore. And just as it prepared the documentation for the Continental Shelf Proclamation, it also prepared the proclamation on fishery conservation zones in areas beyond the territorial sea. In both cases, the work was largely finished and was only to be signed by President Truman upon the passing of President Roosevelt. Each of these proclamations said that the water retained the character of high seas, and in both cases it was understood by the Department of State, the US government, that the United States was setting a precedent, that the United States knew that other countries would follow suit. The Fishery Proclamation isn't as well known as the Continental Shelf Proclamation, but it did instigate negotiations in 1951 for the International North Pacific Fisheries Convention, which was signed by the United States, Canada, and Japan. And this convention, something like a regional fishery management organization today, established a North Pacific Fisheries Commission to oversee and evaluate the condition of the salmon, halibut, and other designated fish stocks in the eastern North Pacific. Our third figure is Maltese Ambassador Arvid Pardo, who gave a stemwinder of a speech in the UN General Assembly in 1967, a call to arms for security and economics of the deep seabed. He worried that there were two trends that would deprive the majority of countries of the wealth of the seabed. The first was the advance in technology and the ability to operate in the deep sea. And the second was a lack of legal clarity or a legal doctrine that would permit coastal states, and in particular the most developed states, from exploiting the resources and leaving the other states without any access or benefit from them. In this respect, Ambassador Pardo sought to fix what he saw as the problem of the Continental Shelf Convention of 1958, which in Article 1 allows coastal states to develop resources out to 200 meters or up to that limit of depth of water that admits of the resources. That is, out to the farthest limit of development of the resource by the coastal state. And as technology increased, of course, that depth would continue to increase. And he feared that perhaps the entire deep seabed would then be claimed by coastal states. The notion of a common heritage sought to have special regard for the poorest nations and also for the largest land-based producers of industrial minerals. Called for a freeze on national claims to the seabed, and that was fine, but it was uncertain still what was the limits of coastal state jurisdiction. Nobody knew. It also called for creation of a new body to negotiate a treaty that considers both economic and security dimensions of seabed mining. This led to the Seabed Committee, which led to the negotiations for the Law of the Sea Convention. Influenced by Ambassador Pardo's call for a common heritage of the deep seabed, in 1969, the UN General Assembly adopted the Moratorium Resolution that stated that states and other persons were, quote, bound to refrain from development of the resources of the deep seabed. And so it was with the finalization of Part 11 in 1982, and then the implementing agreement in 1994 that captured the concept of common heritage of mankind, that stood for the principle that there will be no derogation from the concept of common heritage of mankind. No state can claim or exercise sovereignty or sovereign rights outside of this Part 11 architecture of seabed mining. All rights in the seabed to the mineral resources vest to mankind as a whole, and there's no alienation or removal of the resources outside of that framework, that architecture. In conclusion, these three towering figures of the law of the sea created the foundation that we still stand on. Hugo Grotius, the father of international law, created the doctrine of freedom of the seas. FDR was a champion of coastal state rights and drafted all of the work that went into the Truman Proclamations, both of them, the one widely known on the continental shelf and the one less known on fishery conservation. And then Ambassador Pardo, who promoted the idea that there was a shared destiny and a common heritage of mankind on the ocean's floor. In each case, these men advanced the rule of law through a tangible expression of state practice, not as theory, but as practical rules for governance in a global system. Thank you.
Okay, thank you, Professor Kraska, for your excellent speech on the issue of practitioner's function. He just broadly touched upon the function of practitioners who dealt with ocean matters from Grotius to today. And also we could get a lot of information on ocean practitioners from his wonderful speech. And I want to thank you again. Okay, I want to move to next speaker, final speaker in this morning, and Professor Lee Geun-kwan from Seoul National University. Today he'll speak us on the coping with the public order of the oceans in great flux, with special reference to the training of the law of the sea expert in Korea. So I would like to invite Professor Lee. You have the floor now, please.
Okay. Thank you, Professor Kim. And I'd like to express my thanks to the organizers of this conference, the Korean Ministry of Oceans and Fisheries and the KMI. Well, I'm very privileged and honored to be a speaker this morning. Well, the title of my presentation is rather long, Coping with the Public Order of the Ocean in Great Flux, with a particular reference to the training of law of the sea experts in Korea. The contents of my presentation will be like this. First of all, I'll talk just a little bit about the reception of international law of the sea in Asia. Well, the previous speakers, they all mentioned, both of them mentioned Grotius, and you will see that Grotius, Asia has played a catalytic role in the publication of Mare Liberum, which was published in 1609. So I'll address that question a bit, and then I'll go on to the next point, that is the Korea's active engagement with the law of the sea in the post-World War II period. And then I'll also describe some of the major challenges to the public order of the oceans. And then I'll go on to the main question of my presentation, that is the law of the sea expertise. And there is there is growing need for that expertise in Korea, but there is, unfortunately, there is a dwindling supply of that expertise. And I'll also briefly touch on how to address this important question. As I said to you this morning, the two previous speakers, especially Professor James Kraska, he elaborated on the role of Hugo Grotius, who is generally known as the father of modern international law. And so I'll just briefly touch on Asia's catalytic role in the publication of his book titled Mare Liberum, Open Sea. Well, let me go on to the next slide. Well, this is the manuscript of something known as De Jure Praedae, in Korean, Poekbomnon, and this was written in the early 17th century, but remained unpublished until 1864. So the manuscript was discovered in 1864, and later, of course, it was published and translated into English. The 1609 Mare Liberum was a chapter 12 from this book, which was separately published in 1609. So as was elaborated by Professor Kraska, this book was based on the 1603 Santa Catarina incident, which took place somewhere around close to the Singapore Strait. So in this book, Grotius, he tried to, among others, he tried to justify the Dutch seizure of this carrack, Portuguese carrack known as Santa Catarina, among others, by trying to emphasizing the status of the independent East Indian communities in the law of nations. And this point is also elaborated or elucidated by another book which I have introduced on this slide. So the reason why I'm saying this is that, well, there was a case called Pedra Branca case. This was a case between Malaysia and Singapore, which was decided by the ICJ in 2008. And in this judgment, the ICJ specifically mentioned the relevant passages from de jure praedae, that is in Korean, poekbomnon, right? And this was a very important point in reaching its own decision, the ICJ's judgment. And so in that, one of the most important judgment, the points proposed by the ICJ was that there was an independent kingdom known as Sultanate of Johor, which enjoyed something known as the ancient original title over Pedra Branca. So my point is, again, Asia played a very important role in the publication of this very important book known as Mare Liberum, and some of these points made in the book called De Jure Praedae was picked up by the ICJ in reaching its conclusion in the Pedra Branca case. Let me go on to the next part. That is, let me just a little bit talk about how the law of the sea, we talked about Grotius, and we'll fast forward to the 19th century, and we'll talk about the translation of international law and the law of the sea, how the law of the sea was introduced in East Asia. I think it'll be rather interesting for not just for historical purposes, but in practical terms as well. So here you see this book. It was on the left-hand side. This is the gentleman is known as William A.P. Martin. His name is William A.P. Martin. He was a U.S. missionary who was active in China. And in 1864, he translated Henry Wheaton's book called Elements of International Law into Chinese. So this was the first time ever when a Western international law book was translated into the East Asian language, in this case, Chinese. And here, quite interestingly, you can find some law of the sea terms as found in, this was translated into in Chinese, Wangguo Gongfa, and so in 1864. And here you can, of course, you can already find some of these law of the sea terms there. So I just introduced, sharing with you 5 of these terms. And here, and then this was not just translation. Well, China, when this book was being translated and edited, that is in early 1864, China, Qing China, they employed the legal knowledge based on this book. They employ this for their diplomatic purposes. So this is a highly interesting case. Well, let me be brief about this. Well, in 1864, there was something known as Second Schleswig War between Denmark and Prussia. And the Prussian minister, he was on his way to take up his post in China. Of course, he was coming in a boat. And then he found 3 Danish, Denmark ships, merchant ships, near, close, something known as Dagu Ko, which is a seaport close to Tianjin, Prince Lake Tianjin. And then he ordered these 3 Danish ships captured based on the law of war. And then it turned out that the location of capture was within China's territorial sea, and China, employing the knowledge as contained in the book, William A.P. Martin's book, they said that, well, you are violating China's international rights. And Prussia, they admitted the point, and they released the ships, and then they even paid compensation. So here you see how international law, especially international law of the sea, was introduced into East Asia and was utilized. And then let me move on to the next point. I think I need to speed up a bit. And Korea's active engagement with the law of the sea in the post-Second World War period. First of all, in 1952, January 1952, Korea declared something known as Seungman-Rhee Line or Peace Line. And so there, here, even though the map is rather small, there you can see Dokdo being included within this line. And George Oda, Professor Rothwell mentioned George Oda's contribution to the law of the sea. And George Oda once said that, well, the reason why he started his study of the law of the sea to come up with arguments against this line. So anyhow, this was in 1952. And then there's another map here you can see. Well, on January 1st, 1970, the Korean government declared something known as, promulgated a piece of legislation known as the Act of the Seabed Mineral Resources Development Act. It was in, once again, let me just repeat the date, was on January 1st, 1970. And this piece of legislation was based on the judgment, legal reasoning, as elaborated by the ICJ in the North Sea Continental Shelf case, which was handed down in February 1969. So it was just less than a year that the Korean government picked up the legal reasoning from the judgment, and it implemented that judgment or legal logic to the seabed areas surrounding the Korean Peninsula. So you can see here, these are some of these examples, but Korea actively engaged with the law of the sea in the post-Second World War period. And of course, we can see Korea has emerged as a major significant actor in the law of the sea. And I don't need to go into details of this. But one of them is that law of the sea specialists, Korean law of the sea specialists are quite active on the international stage. So for instance, the current president of ITLOS, Professor Jin Young Park, and then the current a former chairman of CLCS, Professor Park Yong-wan. And so emerging research institutes such as KMI, they are very active on the international stage as well. And then we see, I think this was covered by other speakers, I will just skip, but at the moment we are faced with quite a number of challenges to the public order of the oceans. And especially in this region, in East Asia, we are faced with quite a number of problems, rather specific to the region itself. So again, for the benefit of time, I'll just go on to the next slide. So that's the reason why the law of the sea expertise, there is growing demand for this need and demand for the international law of the sea knowledge, but supply is rather dwindling. It's a growing need because there's a sheer increase in the number of problems in the law of the sea, right? And then there's a need for heightened specialization in each problem area. And then there is another phenomenon, development is that there's increasing interface between the law of the sea and other fields of international law as well. But rather unfortunately, if you look at the Korean situation, so there is growing demand and need for the law of the sea expertise and knowledge, but unfortunately, there is a dwindling supply. So there are many reasons for this. There are many causes for this. But let me just point just a few of those. First of all, Korea introduced something known as the so-called American-style law school system. But as a result of this educational reform, well, some people are talking about, I may putting it a bit dramatically, but withering away of international law education in Korea. And there is lack of long-term, many efforts are made in this respect, but at the same time, one cannot deny that there is a lack of a long-term and systematic support systems for future researchers. And then, of course, there is another problem. There is a shortage of job opportunities for the law of the sea specialists in Korea. And the last slide, Now, how to address this problem? I already mentioned these 2 points, the first 2 points, and then let's move on to the last 2 points. So I think here I use the expression, we need to mainstream the ocean in setting national agenda. So we need to give central position, central importance to the ocean in setting national agenda. So the ocean is not just an isolated, specific subject matter located in the peripheries of a national agenda, but it should come to the central position, and at the same time, it should be mainstreamed as well. And the last point is that, well, this has to do with, to address this problem, addressing the problem has to do with the allocation of resources, which goes down to at the end of the day, a political process. So we need political support. We need support from the Korean public to do that. I think there should be heightening self-perception of Korea as a maritime state. So the Korean people and Korean society has to realize that Korea is a major maritime state. So I think that'll be, I'm sure that all the participants attending this conference, and especially the KMI, we should work together to raise the awareness, or maybe of Korean society, self-awareness of Korean society as a major maritime state. Thank you for your attention.
Thank you, Professor Ji, for your excellent job on your presentation. Professor Lee introduced us the Law of the Sea history research in Asia and Korea, and also stressed that in order to effectively respond to the ocean needs and long-term and systematic support and expanding the number of Law of the Sea expertise are to be urgently needed to become a Korea as a maritime state. And also he pointed out several current ocean issues which Korea has now. So how to solve the problems? He suggests some possible ways. Thank you for that. And okay, now we heard 3 speakers on the presentation. Now it's time to make a discussion. And can I check some voice from James and Donald? Can you hear me? Yes. Okay, good. How are you doing today?
Very good.
Oh, good.
Very nice. Thank you.
Okay, thank you for your active participation to this conference. I do appreciate.
My pleasure.
Okay, we are waiting 3 panelists here. I'll just briefly introduce 3 panelists. First panelist will be Mr. Kim Do-young. He is a research fellow of KMI, former deputy registrar of the ITROS. And second panelist will be Dr. Lee So-hang, vice chairman, Korean Council on Foreign Relations. And also he used to be a professor and dean of research at the Korean National Diplomatic Academy. And the final discussant will be a commissioner of the Korea Coast Guard, Mr. Kim Yong-jin. He's working at International Cooperation Division. So we're going to have some comment from 3 panelists, and I'll give you a mic to the presenters as well. First discussant is Mr. Kim Do-young. Please, you have the floor. Yes, you just 5 or 7 minutes. Please remember that.
Okay, thank you, Professor Kim. I thank the Korean Maritime Institute for inviting me to this virtual conference, and to the Korean Ministry of Oceans and Fisheries as well. I also extend my thanks to Professor Donald Russell, James Kraska, and Lee Gung-kwan for their excellent presentations. In this new year of unprecedented pandemic, we are witnessing these days international conferences are mostly being organized by taking advantage of new technologies. I am quite happy to be part of this new format, and I hope I could be promptly accustomed to this so-called new normal. As a student of international judicial practice, I am following the work of international courts and tribunals, and I was quite impressed with the way the International Court of Justice conducted hearings in the case between Guyana and Venezuela for the first time through video link late June this year on the basis of revised rules, enabling to conduct hearings by using video link, as mentioned by the President Beck of ITLOS. Turning to this morning's topic, enhancing global ocean governance seems to be quintessential in coping with climate change and keeping the oceans sustainable. We may take note of Goal 14 of Sustainable Development Goals set by the United Nations, which aims to conserve and sustainably use the oceans, seas, and marine resources. This goal, which looks crucial for the future of mankind, cannot be achieved without the global ocean governance. When it comes to global ocean governance, government of state are principal actors in carrying out this challenging mission. I understand that their actions in maritime areas are mostly being planned and implemented, taking into account legal principles and rules of the law of the sea. In this respect, I think the institutional legal capacity of governmental agencies of state charged with maritime affairs, namely Ministry of Foreign Affairs and Oceans, Navy, Coast Guard, etc., would be directly relevant to the degree of overall performance of ocean governance of state. How can we strengthen the institutional legal capacity of governmental agencies of various states, developing state in particular? There may be many suggestions to this question. In light of time constraint, I will say briefly some words about the UN Convention on the Law of the Sea and the difficulties lying ahead for students taking it, and I will make one practical suggestion. As we are fully aware, the UNCLOS proper is a very complex and voluminous multilateral treaty. As anyone of the law of the sea people agrees, I believe the interpretation and application of the provisions of the UNCLOS is not an easy task. It demands an extensive research and a high degree of sense of balancing out the different provisions in different parts. Thus, it is simply not possible for students to be versed in the UNCLOS without making arduous efforts and paying careful and detailed attention to its provisions over a long period of time. Its sheer number of provisions and complex content pose daunting challenges to anyone who dares to be an expert in it. As the authentic text of the UNCLOS was drawn up in the 6 official languages of the United Nations, I would like to point out that students whose mother tongue is other than these 6 languages should overcome language barriers first and foremost prior to starting attempt to study. The language barrier is an enormous hurdle and a big disadvantage for most students in Asia in particular. From my personal experience in Europe, I'm aware that people speaking European languages do not fully appreciate the difficulties facing many Asian students who are studying English as a foreign language. I would like to point out further that although the text of UNCLOS remains as it was adopted in 1982, 2 implementation agreements plus new agreements and guidelines, for instance, in the areas of fisheries and the maritime environment, have been subsequently adopted, and the new agreement on BBNJ is currently under preparation at the United Nations. This means an additional burden for the law of the sea students. I understand that a course on the law of the sea is usually offered to graduate students. However, not many universities are offering a course on the law of the sea at the graduate level. In this regard, I believe the world-class professors and scholars in the law of the sea whose mother tongue is English or French should play a more active role in promoting the UNCLOS and other related instruments through various means to a wider group of student and university campuses around the world. This will definitely help to broaden the pool of the law of the sea people in many countries and to enhance their level of understanding of the UNCLOS. My suggestion is based on my personal experience with the lectures available on YouTube. Recently, I have found excellent lectures on ancient Greek history and the history of Western philosophy on YouTube, of which I was totally ignorant. These lectures are very exciting and helpful to me, and I am greatly enjoying them. Likewise, in my view, an online course on the law of the sea, preferably in English, covering topics ranging from its origin, history to dispute settlement, consisting of 20 to 30 lectures, each lasting an hour, would be a great help and benefit to many students visiting study and to junior government officials in many countries as well, who have recently been engaged in law of the sea matters. Before ending my remarks, I would like to ask Professor Roswell whether he also conducts his lectures on law of the sea online and whether students outside his class are allowed to access them. Thank you for your attention.
Okay, thank you, Mr. Kim Do-young's kind comments on the presenter's presentation. Okay, now I'll move on to the next discussion. Dr. Lee, please.
Thank you, Mr. Chairman, Dr. Kim. Well, I have enjoyed very much the three excellent presentations made by Professor Roswell, Professor Kraska, and Professor Lee. Also, I'm very much glad to see Professor Roswell and Professor Kraska again through online Zoom. I'd like to give my best regard to both of them. Hello, Dr. Kraska and Dr. Roswell. In this morning session, this special session, we have examined the history and the development of law of the sea, focusing on the notable contributions made by distinguished scholars and practitioners from Grotius to today. However, I understand that the main objective of this session is to discuss the ways and means how to build and enhance the overall capacity of Korea and other middle power nations to deal with ocean affairs, recognizing the importance of the law of the sea. Simply speaking, I understand that the intended objective of this session is to explore how to strengthen our capacity in managing the ocean issues, including the training and education of the law of the sea experts. I would like to call it maritime capacity building. In making my comments, first I would like to make some general points which have been suggested by many scholars in recent years to improve our maritime capacity building. And later, I would like to raise a couple of questions to each presenter for further discussion of the subject. According to the United Nations Development Program, UNDP, capacity refers to the ability of individuals and institutions to make and implement decisions and perform functions in an effective, efficient, and sustainable manner. At the individual level, capacity building refers to the process of changing attitude and the behaviors, imparting knowledge and developing skills, while maximizing the benefit of participation, knowledge exchange, and ownership. At the institutional level, it focuses on the overall organizational performance and the functioning capabilities, as well as the ability of an organization to adapt to change. Based on this definition, I would like to make 4 general points to enhance maritime capacity building. First, in this session, I think we have limited ourselves too much to the legal aspect of the oceans. But there is a need to expand our perspectives to include all aspects of the oceans. As we all know very well, the area of oceans for any government is a complex and often ambiguous policy field. The ocean space is governed by a variety of international treaties and agreements that govern everything from maritime boundaries to fishing regulations. It gains its complexity by combining and integrating diverse maritime challenges. These are associated with traditional defense and the sea power concerns, such as the protection of sovereignty and borders, human security challenges, such as the welfare and food security of coastal populations, marine safety issues, including search and rescue, disaster response, or port security, as well as issues of environmental protection. So in consequence, secondly, maritime capacity building not only requires dedicated policies and strategies capable of integrating and prioritizing responses to various maritime issues, but also the close coordination of the diverse agencies responsible. Since maritime affairs is a cross-cutting issue, the number of agencies involved can be substantial, including but not limited to the Ministry of Oceans, Navies, Maritime Police, Customs, Port Security, or environmental regulators. Also, non-governmental actors play a considerable role, ranging from industrial fisheries, the transport, tourism, and the extractive industry to recreational users of the sea. And thirdly, maritime capacity building is not primarily a technical challenge. It requires broad political commitment. It requires the ongoing commitment of all users of the sea and the political recognition of the importance of the sea. Lastly, but not least, I believe that building maritime capacity is an effort of decades rather than years. So we must have a long-term plan in order to enhance maritime capacity. Now I would like to raise some questions to each paper presenter for further discussion of the subject. First, 2 questions go to Dr. Kraska. Well, Dr. Kraska, Professor Kraska, has examined 3 enduring legacies in the law of the sea history: Hugo Grotius, President Roosevelt, and Ambassador Pardo. And among these, in particular, Ambassador Pardo of Malta, as we all know very well, introduced the concept of common heritage of mankind at the UN General Assembly meeting in 1967, which triggered the opening of the 3rd UN Conference on the Law of the Sea. No doubt, the concept later became the philosophical foundation of the UN Convention on the Law of the Sea. As far as the concept common heritage of mankind is concerned, I would like to add one more person who contributed a lot to the establishment of the concept. The name of the person is the late Madame Elisabeth Mann-Borghese, daughter of great German novelist Thomas Mann, who founded International Ocean Institute in Malta in the early 1970s with Ambassador Pardo. Madame Borghese worked hard in her endeavor to establish the vision of the ocean as the common heritage of mankind, out of which cropped out the adoption of the UN Convention on the Law of the Sea. I spent 1 year at the Dalhousie Law School as a postdoctoral fellow in the mid-1980s when she was there, and I had several chances to talk with her. She told me that she gave the idea of a common heritage of mankind to Ambassador Pardo when she worked with him in Malta. So I think Madame Borghese was a diligent activist in achieving her principle of the common ownership and the sustainable utilization of the ocean resources to benefit of mankind as a whole. So my question to Professor Kraska is that, could you also give some credit to Madame Borghese in addition to Ambassador Pardo as far as the concept common heritage of mankind is concerned? That's my first question to Dr. Kraska. And my second question to Professor Kraska is related to the talents and attitudes of the practitioners on the law of the sea issue. As a professor who is teaching at the Naval War College, what are the desirable dispositions and the qualities for practitioners on the law of the sea and other maritime-related affairs? Those are 2 questions to Dr. Kraska. Next, 1 question goes to Professor Egan Kwan. Professor Lee emphasized the importance of the training law of the sea expert in Korea. If we recognize that a lack of expertise in some African and Southeast Asian countries in managing their maritime domain over the past years has allowed lawlessness and crime on the seas to proliferate. The importance of training competent and able experts in the law of the sea can never be overemphasized to protect our national maritime rights and interests. But I think that more effort is required to go beyond the training individuals. As I mentioned earlier, the issue of maritime capacity building has two dimensions, individual and institutional. So in case of Korea, what kind of capacity building challenges do we have at the institutional and organizational level? So I would like to more elaborate opinion from Professor Lee. Lastly, but not least, one brief question to Professor Roswell of Australia. Professor Roswell examined the role and impact of scholars throughout history of law of the sea. In his explanation on Australian national influence and impact was very impressive. So my question is to Professor Roswell, from the experiences of Australian scholars on the law of the sea, what specific lessons could you give to Korea in training and educating experts on the law of the sea and other maritime related issues? That's just a brief question to Professor Roswell. Thank you.
Okay, thank you, Dr. Lee's comments on questions as well. And I want to take answer after the final discussion. Now, Commissioner Mr. Kim Yong-jin, please, you have the floor.
Good morning. I would like to thank Professor Donald Roswell, Professor James Kraska, and Professor Lee Kyung-kwan for the great presentations. And I'm honored to be here today at this conference with excellent scholars. I hope that the COVID-19 will end soon so that I can meet you in Korea next time. I'll talk about COWOC, Korea Coast Guard, and maritime law experts shortly. Many nations have a Coast Guard agency. It is a frontline organization in charge of law enforcement, and foreign vessels are also subject to the law enforcement. Therefore, a high level of expertise is required in enforcing both domestic and international laws. However, the Korea Coast Guard, KCG, has been struggling with many challenges. Generally, Coast Guard agencies have been enforcing the maritime law around their own territorial waters. So there is a trend that most of countries interpret maritime law only for their own national interests. The KCG has always been cautious when we interpret the UNCLOS because they are difficult and ambiguous. Even a small maritime friction with a neighboring country can be a diplomatic issue between countries. Furthermore, it can even become a sensitive issue that affects domestic issues on security, economy, and culture. The KCG considers both domestic and international laws dealing with such matters. Let me give you an example. Between Korea and China, there are overlapping areas in the EEG. Both countries have one claiming over the zone, and a maritime agreement between Korea and China has not been made yet. The Korea and China's research vessels do their activities in the EEG claimed by both countries. There is no problem with that, according to the UNCLOS. However, when foreign research vessels are in their waters, both countries watch over Coast Guard vessels of the other countries, because control vessels of both countries follow closely their own research vessels to protect them. There seems to be no problem too, but the two Coast Guard agencies insist on the right of each state, and sometimes invisible tensions between them last 4 hours or days. The KCG is preparing for many scenarios. They include the invention of our patrol vessels in case where China Coast Guard vessels interfere with our rightful research activities. We cannot clearly see most of matters in the UNCLOS. We cannot find similar cases elsewhere. That's why the role of experts are important for the KCG. We have minimized the risk of international conflict. The KCG has also been looking into various measures case by case, consulting with law experts. If we take actions only for our national interests, it would cause strong protests from neighboring countries. So it is very important for a Coast Guard agents to cooperate closely with law experts. However, only 5 KCG officers hold PhD degrees in the law of the sea. That's why we made a consulting body, so we can consult with law experts to strengthen our expertise. Since then, we have been holding seminars attended by experts at least twice a year. We discuss current issues and get useful advice on proper measures. And we are also making various efforts to have our own experts. First, we provide our officers with education materials. So we help them to acquire basic UNCLOS knowledge. Second, we encourage our officers to study abroad or obtain degrees in the maritime law. The KCG aims to live up to the international standards. Experts in the law of the sea can play an important role because academic scholars have been contributing to ensure global maritime security. I look forward to great contribution from maritime law scholars. Thank you.
Okay, thank you, Commissioner Kim, for your kind comments on the role of Korea Coast Guard and the importance of those experts for their job doing. And you definitely need a lot of those expertise help, like me. And now another special guest is waiting for us on the line. And so I would like to invite Professor Wang from National Taiwan Normal University. Professor Wang, are you there?
Yes, I'm here.
Okay, please make comments. Just quickly, please. Yes.
Okay, right. Thank you. Yes. Thank you.
Go ahead. Yes.
Thank you, Chairman. Okay. Thank you, Chairman, Professor Kim, and good morning, ladies and gentlemen. First of all, I would like to thank the organizer, Korea Maritime Institute, for including me today. Although this is a virtual conference, I trust that this would also be an excellent gathering for academic discussion. The topic of this special session is the role of the law of the sea and its experts in global ocean governance. And I want to join my Korean colleagues to have our discussion go further to the issue concerning global ocean governance. I have several questions for Dr. Kraska and Professor Roswell. First, for Dr. James Kraska, you mentioned 3 enduring legacies in the law of the sea, which are freedom of the seas, EEZ, and continental shelf. as well as the common heritage of mankind. As we understand, there is an intergovernmental conference to consider the elements and to elaborate the text of an international legally binding instrument under the UNCLOS on the conservation and the sustainable use of marine biological diversity of ABNJ. However, this conference had already met 3 times and was expected to have its 4th meeting in the past March, but the General Assembly decided to postpone the 4th one due to the COVID-19 pandemic. So far, it seems that the date for reconvening would be difficult to be decided. So my question for Dr. Kraska is, how do you think about the future development of the discussion or negotiation on the issues of BBNJ? What are the factors which would influence or even disturb the consensus building for the BBNJ? And secondly, my question is for Professor Roswell. For those scholars whom Professor Donald Roswell mentioned, including Professor Roswell yourself, I believe that they really have great global influence and impact on the development of the law of the sea. And more specifically, many of them are the pioneers on the issues of the international fisheries law. Therefore, I want to connect the fisheries law issues with global governance, which is the impact of RFMO on combating the IUU. We will also understand that FAO calls upon all states to implement the IPOA IUU and to cooperate between states or RFMOs so that combating illegal fishing activities could be effectively addressed. Having said so, the reality is that the IUU is still existing. Therefore, my question for Professor Roswell is, do you think RFMO working efficiently in dealing with IUU fishing, especially under the framework of global governance? So those 2 are my questions for 2 professors. Thank you very much. And also, I would like to thank you, Chair, Professor Kim. Thank you.
Okay, thank you, Professor Wang, for your questions and comments. Now we're running out of time, so we don't have enough time. All the just 3 minutes left. So before ending this session, I would like to have time for answering from speakers. Already, Dr. Lee So-hang asked a question to Professor Kraska and Roswell and Professor Lee, and then please answer that. And then after that, Professor Kraska and Roswell, please answer the question raised by the Professor Wang. Yeah, please, who is first? Professor Kraska, can you answer for the questions, please? Yes.
Sure. Thank you very much for the questions, and thank you for KMI and the Ministry of Oceans and Fisheries for the invitation to this fantastic event. So the question was with regard to credit for the concept of the common heritage of mankind and whether Madame Borghese deserves some of that credit. I'm sure she does, and I don't know her as well as you, but I do know that in 1975, she credited Arvid Pardo with that concept in his 1967 speech. In fact, I would even go further. All of these concepts have had a number of contributors, including back in 1898, Professor de la Pradelle, who proposed that even the territorial sea, like the high seas, was the heritage of mankind. And then in the early 20th century, he proposed that there ought to be some sort of worldwide organization for ocean governance and an equal access and sharing of the rights of the sea. So I think there are other people, obviously, besides Ambassador Pardo. With regard to the qualities for practitioners, my view is formed through US delegations at the IMO, which is that my view is that people have to have some flexibility and not think in zero-sum terms, but think constructively and creatively to try to work through issues. The danger, of course, is that you end up with a constructive ambiguity that just kicks the can down the road. And so obviously these are not easy questions. That leads to my view on the third question, and thank you so much. And this is the feasibility of a internationally legally binding instrument on biodiversity beyond areas of national jurisdiction. And my view there is that I do believe that we will have a third implementing agreement for the law of the sea, but maybe it will not fulfill all the aspirations of its greatest proponents and might be more effective or more feasible if it focuses on things such as area-based management tools and environmental impact statements. And I would suggest that we're less likely to get agreement on the more difficult issues such as access and benefit sharing for marine genetic resources. Thank you so much for the questions.
Okay, thank you for your answering for all questions. And now, can I move on to the Professor Rosso? Are you ready to answer for that questions?
Yes, thank you.
Please.
And can I also just echo Professor Kraska's comments in extending my thanks to the organizers. Professor Lee phrased a remark in terms of education on international law and law of the sea in Korea. And by contrast to the Korean situation, most Australian law graduates from Australia's major universities will have studied international law. And in fact, it's a compulsory course here at the Australian National University. And many of Australia's major Australian universities also offer courses in law of the sea at the undergraduate level. So that turns me to online teaching. And in fact, this semester, starting in August, I've been teaching 30 master's students in an online law of the sea course. And I have 55 undergraduate students that I'm also teaching in an online law of the sea course. And those master's students are students that are scattered all over Australia, and some are in fact located in parts of Asia because of the difficulties of those students to be able to travel into Australia because of the pandemic. Now, these events have all been forced upon us in terms of the way in which we've had to adjust and modify our teaching. But it may well be that as a result of this experience, we engage in more online teaching. And I think that's a good thing, if only because it will allow us to reach out to many more students in many locations across a very big country like Australia, but also around the world. And then finally, to the question in terms of IUU fishing and RFMOs, my sense there is that the record is mixed. I think there have been some very good efforts to combat IUU fishing through the development of RFMOs. But I guess one of the critical challenges that RFMOs are going to face moving into the future is the ability to continue to engage in compliance and enforcement, predominantly because of the costs associated with those activities. And we know that many countries in various parts of the world, including here in Australia, are struggling with very significant financial challenges as a result of the pandemic. And I think that will see some ramifications in terms of the ability of Coast Guards and other maritime law enforcement officials to be able to engage in RFMO compliance and enforcement mechanisms, especially given the costs involved in those activities. Thank you, Chair, once again.
Okay, thank you, Donald, for your kind answering for the questions. Now let me move on to the Professor Lee for you.
Thank you, Professor Kim. Well, first of all, I'd like to thank Professor Rothwell for enlightening us about the situation of legal education, international law education, and the law of the sea education in Australia. I became quite envious of your situation. And so I think I will share that information with my colleagues and the Korean officials. So I think this is very very important piece of information for us. Thank you. And let me go on to the question raised by, put to me by Professor Lee So-hang. And I think the concept he used, that is maritime capacity building, is a highly instrumental conceptual prism through which one can look at the questions we are dealing with. So I'd like to thank him for proposing this very important concept. Well, his specific question was, what are to be done about training of experts, law of the sea experts at the institutional and organizational level? Well, yeah, I think this is very important. So let me just adduce the example of a specific example of the late professor and Judge Park Chun-ho. Right? He was a brilliant law of the sea specialist, authority known throughout the world, and in addition, he had a wide-ranging global network as well. But this was all done, unfortunately, in my opinion, at the individual level. With his passing away, especially his, I think, network is all, just died with him. So I think we in Korea, we have an excellent individual law of the sea expert, but unfortunately, it hasn't been institutionalized. So we need to be alert to that aspect of the question, and maybe KMI or maybe the Korean government should play a role how to institutionalize our expertise. I think that will be a very important task for us. Thank you.
Okay, thank you, Professor Lee, answering for the questions. We are already time's over now, so as a moderator, I would like to appreciate all speakers and commentators, and also participants as well. Today and this morning, we touched upon several law of the issues, particularly the role of law of the sea and its experts in global ocean governance, such a hard and valuable topics we already touched upon today. So I would like to keep in mind for all the questions answering on the issues. So I would like to officially close today's special conference. Thank you.
Thank you. I'd like to thank to all the speakers and audience for your contribution. The afternoon session will begin at 2 p.m. To online participants, please make sure to join us here again at 2 p.m. Thank you very much. 좀 쓰겠습니다. 네, 웨비나에 안 나가죠? 네, 네, 오키드룸에 계신 내외 기빈분들께 안내 말씀드리.
Good to see you.
Good afternoon, ladies and gentlemen. We are going to get started session 1 now. All speakers and discussants, please take your seats. 행사장 외에 계시는 참석자분께서는 세션 1이 곧 시작하오니 입장해 주시기 바랍니다. 팀장님, 배경음악 좀 줄여주십시오. Now we start the session 1. Moderator of this session is Professor Park Yong-an, the member of CSCS. Now I will turn the session over to him.
We're gonna have now afternoon sort of CS1 recent development of the outer continental shelf and area, and moderator Yong-an Park. I am a CLS member until 2022 March. But today we're going to have 3 speakers and 3 discussants. And then this famous sort of theme concerning about container shelf area and area. And there are 3 speakers. Firstly, Srivasan Markshan Rajan, and second, Galo Carrera, and third, Warwick Gullet, and discussant Woo Kyung-sik, Professor Gangwon National University, Bang Ho-sam, Professor Jeonnam National University, and Park Yong-gil, Associate Research Fellow, KMI. And first, Dr. Rajan, former director, National Center for the Antarctic and Ocean Research, India. So former foreign marine organizing member, CLCS member. So his talk will be national resources of the continental shelf beyond 200 nautical mile, the scientific and legal challenges of their sustainable management under the law of the sea. So this is very important one. And Carlos Carrera, the former member of CLCS also, annexed to the United Nations continental continent on the law of the sea from the third conference to 2022, the 20. And Warwick Gullet, Professor, University of Wollongong, competing interests in the development of international seabed authorities, exploitation, code, environmental and protection, visibility of the resource extraction, and out of common heritage, so on. So first speaker, Dr. Rajan, he will have the honor, his great research, about 20 minutes or less than 20 minutes, so on. Okay, Dr. Rajan, are you okay?
Yeah, I'm okay. Can you hear me?
Okay, you go ahead.
Okay. Yeah, thank you very much, Professor, and a very good afternoon to you all. At the outset, I would like to express my thanks to the organizers of the conference for the kind invitation extended to me to be with you, at least in the virtual space today. More so for giving me an opportunity to share with you some of my thoughts on the exploration of mineral resources in one of those unique areas of ocean space, namely the continental shelf beyond 200 nautical miles, and the geoscientific and legal hurdles to their sustainable exploitation, if not today, sometime in the future. So without much ado, let me just go on to my PowerPoint presentation, and here you have, let me just start the session. And okay, this is the title of my talk, and now, this is the title of the talk, natural resource, the continental shelf, etc., etc. And what exactly, the first question which comes to the mind, what exactly do you mean by an extended continental shelf? This is a schematic cross-section across the seafloor from the land to the deep ocean basins. We have the continental shelf which merges with the land area and it merges with the rise through a continental slope. And beyond the rise here, the deep ocean, this is what a geologist would definitely try to identify. The continental shelf plus slope plus rise equals continental margin. And now the United Nations Convention on the Law of the Sea fundamentally seeks the subdivision of the ocean space into maritime zones. Most importantly, with the rights and responsibilities of a coastal state being phased down as you go from the land towards the ocean. Thus, beyond the territorial sea of 12 nautical miles, a coastal country has a jurisdiction of two kinds of maritime zones: an exclusive economic zone, or EEZ, up to 200 nautical miles from its baseline, and over which a country may exercise sovereign rights over the seabed and the waters above, as well as an extended continental shelf beyond 200 nautical miles, over which the state may exercise jurisdiction only over the seabed, but not over the overlying waters. My talk is exclusive to this part of the maritime zone. Now, the question that can definitely be asked in the first instance is, what exactly are the sovereign rights we are talking about of a coastal state over its continental shelf? Article 76 of the UN Convention states that a coastal state has sovereign rights over the continental shelf for the purpose of exploring it and exploiting its natural resources. And Article 76 then goes on to define the natural resources as consisting of the mineral and the non-living resources, seabed and subsoil, together with the living organisms belonging to sedentary species. So what exactly does it mean here? What are the potential mineral resources that can be expected of? Now that we have defined the continental shelf and its extension, what are the potential mineral resources that can be expected over the extension of the continental shelf beyond 200 miles? A straightforward answer is definitely not much right now, primarily because exploration for non-living resources beyond 200 nautical miles is still very much in a state of infancy. As a matter of fact, even the outer limits of the continental shelf beyond 200 nautical miles are set to be defined, delineated, and delimited for a good majority of the coastal states. Be that as it may, this schematic shows the distribution of natural resources of the ocean basin across a section, starting off from the land to nearshore areas to shelf, slope, rise, and finally going across into a spreading center. The distribution of natural resources of commercial interest in this area ranges from the place and deposits to diamond in the nearshore areas, iron sands and evaporates through phosphorates on the shelf slope. Here we have that hydrocarbons and gas hydrates over the continental margin, the manganese nodules over the abyssal plains, and cobalt-rich ferromanganese crust fringing some of the sea mound and then cutting across it into the Rift Valley or the spreading center. You have got a polymetallic sulfide. Now again, the question is that, do any of these mineral resources which I have shown here occur on the extended continental shelf as well? The places, the diamonds and evaporates are certainly not likely to occur as become commercially important resources on the seafloor beyond 200 nautical miles, and that can be discounted straight away. But what about modern phosphorites? The chances of this is the map. It shows the occurrences of modern phosphorites along the coastal areas, as well as some of the relic phosphorites occurring on the sea mounts. The chances of modern coastal continental shelf slope phosphorite nodules and concretions occurring beyond 200 nautical miles are pretty much slim. As you can see here, these are the easy areas of most of the countries, coastal states I mean, and the known occurrences of modern day phosphorates are restricted to less than 200 nautical miles. As you can see here, most of these modern day phosphorates are occurring in the upwelling zones. They occur in the zones of upwelling within the easy areas at water depth of about 200 to 400 miles. However, some of the relic phosphorites of the submarine elevations falling on the extended continental shelves could become economic propositions, if not today, sometime in the future. For instance, you have the known phosphorites of the Chatham Rice of New Zealand. Here you have located in a water depth of about 400 meters and about 500 kilometers offshore. Mining contract, as I understand, has already been granted, but environmental considerations have delayed the economically feasible exploration and exploitation of these phosphorites in this area. Now, we have three major seabed resources: the polymetallic nodules, the cobalt-rich ferromanganese crust, and hydrothermal deposits or hydrothermal sulfides, the exploration for which in the deep ocean is being guided and monitored by the International Seabed Authority. Here got this polymetallic nodule occurrences here, the hydrothermal sulfides, and what you have got here are the cobalt-rich ferromanganese crust. Let's consider the possibility of occurrence of these mineral resources on the extended continental shelf beyond 200 nautical miles. As you can see here, this is the EZ of most of the coastal states, and you can see some occurrences or the possibility of some of these occurrences beyond 200 nautical miles into the possible extended continental shelf. Let's start with the first one: hydrothermal vents and polymetallic nodule, polymetallic deposits, I mean. And they occur in diverse geological settings. They occur primarily along the spreading centers, as for instance along the East Pacific Rise, the Galapagos Ridge, the Mid-Atlantic Ridge, as well as Central Indian Ridge. They also occur along the volcanic or back-arc basin settings, as for instance along the Tonga-Kermadec Ridge, the Manus Basin, the Mariana Arc, the Isu-Ogasawa Arc, and finally, I got some deposits on mid-plate seamount and diode regions. Here, this is a much better picture, which shows the hydrothermal systems of polymetallic sulfides occurring in modern ocean basins. As you can see here, over 400 sites of potential mineralization or potential hydrothermal systems are known, but only about 140 are economically significant. And this is the East Pacific Rise, where you have got occurrences here, and the Mid-Atlantic Ridge, as well as the back-arc basins. So now, a good majority of the most important thing to notice is that by and large, a good majority of these occurrences are beyond natural jurisdictions. Because of the remote locations from the shore, it's unlikely right now that these seafloor deposits will become mining targets in the foreseeable future. Although, as on date, the International Seabed Authority has signed 7 contracts for exploration of polymetallic sulfides with the contractors representing China, France, Germany, India, Korea, Poland, and Russia. You have got these contracted areas. This is the area which has been contracted to China, the area which has been given to India, Southeastern Ridge, and Southern Ridge, to Germany, and to Korea. And this is the polymetallic nodule occurrence in the Indian Ocean Basin, which has been contracted to India. But the important point to notice here is that most of these occurrences which have been contracted out for exploration and possible exploitation are falling outside the EEZ and mostly outside the extended continental shelf of the nearby coastal states. Yes, but can you discount the possibility of the occurrence of some of these deposits or some of these mineral resources on the extended continental shelf? As you can see here, this is the back-arc basin settings in the Northwestern Pacific Ocean. Back-arc basin-related subduction zones are also important sites for base metal gold, especially for base metals and gold mineralization. These are the spreading centers in the back-arc basins. For instance, you have got as famous, I don't know whether it's famous or notorious, the Manus Basin, the Pac-Manus hydrothermal deposits, which are scattered along a 10-kilometer long crust. This is the Pac-Manus area, which is where you have got known hydrothermal deposits scattered along a 10-kilometer long cluster section of an active volcanic ridge in the Bismarck Sea, Eastern Manus Basin. The first possible commercial enterprise by Nautilus Minerals Inc., which was scheduled to commence its operation late last year at a prospect known as Solwa-1 in the territorial waters of Papua New Guinea, has however turned out to be a non-starter for a variety of reasons, and the company has recently declared its bankruptcy. However, the shallow depths less than 1,500 meters and high gold content of almost 18 ppm nonetheless makes such deposits or such sites potentially valuable for mining. The possibility of similar occurrences elsewhere in the back arc areas and falling within the EEZ as well as the extended continental shelf of the Western Pacific Islands can definitely not be ruled out at this stage. Next in my list is the marine manganese nodules. Their abundance, composition, and their occurrence as loose material, they're just like that, they're waiting to be picked up. As you can see here, make them very potentially attractive to future mining. This is the occurrence of nodules on seaweed, and this is a typical nodule, the kidney shaped. I'm sure most of you must have seen pictures of this umpteen times. And the nodules basically comprise of iron and manganese oxide that can contain economically valuable concentration of nickel, cobalt, and copper, together making up about 3 weight percent, in addition trace amounts of molybdenum and the platinum. And nodule accumulations of economic interest occur in 4 major areas: the Clarion-Clipperton zone of Poro Basin, or the Purbeis Basin, as well as on the Central Indian Ocean. So these are the areas which have got a potential. And as you can see here now, again, some of these occurrences are on the fringe of exclusive economic zone. There's a possibility that once you have the extended continental shelf delineated and demarcated, some of these nodule occurrences might fall within the extended continental shelf. And now coming to the South Pacific area, the nodules occur within the EEZ and potentially beyond. Manganese nodules are found in the Cook Islands, for instance, the famous occurrences of Cook Islands, islands of Kiribati, and the island nations of Tuvalu and Niue. What you can see here are the occurrences of manganese nodules falling within the EEZ of islands in South Pacific as well as offshore areas. So there's a possibility that polymanganese nodule, polymetallic nodules might become potentially attractive mineral resources on the extended continental shelf in the future. Next is again the cobalt-rich ferromanganese crust on seamount. They're primarily nothing like, they're almost like, I would say, the manganese nodule. The only difference is that the cobalt content constitutes about 2% as compared to the manganese nodules. Composition is similar. It can comprise of manganese and cobalt, copper, nickel, and platinum. And they also occur at depths about 1,000 to 3,000 meters. And they occur as coatings and incrustations of hard rock substances. So these are the coatings of cobalt-rich crust on seamounts and submerged portions of islands. And mostly by and large about around island states in the Pacific, and especially in the prime crust zone of Japan. What you see here are the occurrences of cobalt-rich ferromanganese crust in several areas of the seabed. So cobalt crust, like the manganese nodules, are also likely to be among the most commonly occurring mineral resources on the extended continent. Yes, now oil and natural gas, hydrocarbons would certainly continue to represent the most mature and well understood mineral resources on the extended continent. This is one mineral resource where there's always a demand, and the demand, as long as it keeps pace with the supply, the technology will definitely improve. When with technology improvement, as you can see here, about 37% of the global production of offshore oil, of oil comes from the offshore areas, whereas it's just about 28% for global. So there's always a demand for offshore sources of hydrocarbons. And with technology improvement, it's now possible to extract oil and gas at ever greater depths, even beyond the EEZ. And the record is held by the depth of over 3,050 meters in the Gulf of Mexico, while the record for subsea gas production is also around 3,000 meters. And if you look at this picture here, between 2007 and 2012, over the period of 5 years, the volume of offshore oil and gas fields discovered in deep water areas has gone up. See, this is the area, these are the locations. I mean, these are the areas where you've got a deep water, ultra deep water occurrences. The amount of oil which is being extracted from deep water resources is comparatively very high as compared to shallow water as well as onshore areas. So there you have. And there are many causes. The idea is that when you have got a continental shelf extending beyond 200 nautical miles, and which has got sedimentary sequences in excess of at least 1 kilometer, you can have potential hydrocarbon resources. I put potential within inverted commas because there's always a potential of hydrocarbon resources where you got extraordinarily thick sedimentary sequences. Of course, there are other geological factors involved, like you need to have cap rock, you need to have a trap, you need to have a source. Leaving apart all those things, there is a potential. And currently only a few prospecting or exploratory activities are on in the external continental shelves, chiefly of Angola, Brazil, Eastern Canada, Northern Norway, and the US, which is definitely not a state party to the convention. Just wanted to highlight that aspect. And among these, Canada stands out as a pioneering state to already issue developmental license, because already issued developmental licenses for exploration beyond 200 nautical miles in the deep waters of the coast of Newfoundland. And now we have got these interesting deposits of gas hydrates in the maritime. Gas hydrate, this is how a gas hydrate looks like. It's a crystalline, but it is nothing but a molecule of methane, for instance, caged within a water molecule. It is produced at low temperature and very high pressure. They occur worldwide as layers or laminar units interpreted through sediments. You can see the location just about everywhere near the coastal areas. You can expect occurrences of gas hydrates. The important thing is the gas hydrate is not a mineral deposit, I would say, per se, strictly speaking, the definition. But they are estimated to hold many more times methane than presently exists in the atmosphere, and up to twice the amount of energy. So this is an important source of energy compared to other fossil carbon-based fuels. Okay, as I said, it's known from just about everywhere of the coast of Canada, Alaska, west coast of Norway, and approximately about 220 deposits have been identified across the globe in the sediments of the slope as well as beneath the polar floors. The important thing is that they occur at depths greater than 500 meters on the continental slope and continuing to depth beneath the seafloor determined by the geothermal. So there is a possibility of the occurrence of gas hydrates in several other and contiguous to several of these coastal states, especially in the continental rise and extended continental shelf of many of these coastal states. So now, coming to the question here. We know there are, despite all-round depth to the sea, just about 5 years back, if you look back in time, there's been a lot of declarations saying that by 2020, 5% of the world's minerals, including cobalt, copper, and zinc, could come primarily from ocean floor. However, if you just look at the time, right now we are into 2020, if you look at it, what you can see here is that barring oil and natural gas, seabed exploration and exploitation for many of the sources which I have listed remain woefully inadequate. And it's almost non-existent when it comes to continental shelves beyond 200. What could be the reason for this? Number one, uncertainty on the resource abundance beyond 200 nautical miles. As I have shown you, it's likely that the mineral resource potential in the extended continental shelf areas of most of the coastal states can be only modest at best. Exceptions are, of course, the polymetallic nodules, cobalt crust, and hydrothermal sulfide deposits in the case of only some of the coastal states. Also, definitely oil and natural gas. So there's a lot of uncertainty about the resource abundance. Number two, which is definitely not which is exactly not a challenge or a bottleneck, but I thought I should highlight this fact, saying that the time frame for considering and recommending on the submissions made by coastal states for an extended continental by the CLCS. If you look at the time frame within 2001 December and 2019 December, a total of 85 submissions, including partial, joint, and revised, has been made by the different continental coastal states. As on date, however, recommendations in respect of only 35 submissions, totaling, aggregating to about 45% of the total submissions may have been made. Of course, I agree that delineation of the outer limits of the continental shelf is not a prerequisite for a coastal state to explore its extended shelf, as clearly stated in Article 76, paras 2 and 3. However, many of the states might be tempted to hold back on their activities till such a time the recommendations are made and the state has completed its exercise of delimitation of the shelf, which is also critical to this whole exercise. And plus, it's a very cost-effective and cost-intensive exercise. Coming now to the scientific and technological challenges, the exploration and subsequent exploitation of mineral resources related to one is distance of occurrence from the land. The farther that it occurs from the land, the more the cost involved in extraction or exploration and exploitation. Oceanic depth, the deeper the depth, the more the money involved at the site and the spatial extent of the occurrence. The more the spatial extent, the chances of locating a minerals are much more as compared to, let us say, look at hydrothermal deposits, for instance, compared to a manganese nodule. Definitely, the spatial extent for a polymetal nodule is much more, so it's easier to identify, locate, extract as compared to deposit. The cost economics and the demand for acoustical resources scarce on land and available on the ocean. If there is a demand for a particular mineral, for instance, the ocean or oil and natural gas, which I was talking about a while back, the cost economics work in favor of that. So even if the deposit occurs offshore at greater depths, there is a tendency for a possibility to go explore and exploit the resources because of the paucity of such a resource on the nearshore areas or on land. And number C, the present scientific and technological know-how for exploration, development and exploitation. What exactly does it mean? Just look at it quickly. I'll go through these three aspects. Oil and natural gas, exploration, exploitation technology right now has been very well developed, and due to sustained demand is continuing being developed across more frontier areas. So as and when the need arises, definitely there's going to be a technological revolution concomitant with the need, and some new extraction stemming improvements might be called for, and it will definitely be there. Hydrothermal sulfides, nodules, and crust. Right now, we have got about 30 exploratory contracts which have been awarded to several coastal states by International Seabed Authority in areas outside their extended continental shelf in the area as within inverted commas. So definitely, there's going to be a lot of developments in geological and geophysical methods of exploration and as well as the mining also. So these technology developments in the offshore areas, definitely some of this technology also might go into seeking for mineral resources. Well, yeah. Gas side race, definitely the extraction of natural gas under laboratory conditions has been tested. Technologies are under development, seeking to establish a working scale extraction system that's both cost-effective and safe.
Okay.
National policy already. Yeah. So I'll just environmental impacts are there. We need to work on that. That's perhaps the most important thing, which is keeping the exploration of mineral resources beyond continental, the extent of continental back.
Okay.
So legal hurdles, I will not talk about it. I mean, concluding that I will say that there are major resources in the continental beyond 200 nautical miles, but they can be only modest. I think I would just stop with this one, and thank you so much for your patient research. I seem to have run out of time. Thank you very much.
Thank you. Thank you. Thank you.
Thank
Dr.
you.
Thank you, Dr. Rajan. So we are going to move to the Dr. Carol Carrera directly. So we're going to look at the Dr. Carrera's his view. Okay, good. Dr. Carrera, you have floor. Okay.
Thank you very much, Mr. Chairman. Let me make sure that you can listen to me. Can you listen to me?
Yeah.
Very good. Well, thank you very much to the organizers and to KMI for the kind invitation to provide a commentary to Annex 2 to the United Nations Convention on the Law of the Sea. There are a number of provisions that have been commented already by legal scholars, but none of those commentaries yet introduces the experience of the work of the Commission over the last 20-some years. So my presentation, the overview of my presentation is the following. I will first analyze the legal development of the Annex 2 to the United Nations Convention on the Law of the Sea throughout the third conference, particularly as it relates to the between the third and the ninth sessions. And my commentary based on that development will address in particular paragraph 1 of Article 2, paragraph 5 of Article 2, paragraph 1 of Article 3, Article 4, 5, 6, 8, and 9 of that annex. The sessions of the convention, there were 11 sessions in the convention, and the key session where the transition was made between having a draft that did not include Annex 2 and the first draft of Annex 2 as part of an official document of the Commission took place during the 9th session. Having said that, there were other sessions before, particularly between the 3rd and the 4th session, when the beginning of the development of the new concept of the continental shelf was envisaged. And there were others that as well contributed to the development of that annex. You will recall that during the 3rd session, it is the first time that in the informal single negotiating text, we incorporate the concept of the extension of the continental shelf up to the outer edge of the continental margin, in addition to the limit of the 200 nautical miles. During the 3rd session, there were 2 proposals, one made by the United States and the other one made by the Evensen Group. Both of those proposals already contemplated the existence of an annex. It is in the footnote to the proposal made by the Evensen Group, for the first time, we refer to the Continental Shelf Boundary Commission as an independent organ with some of the elements that will later on be incorporated into the discussions of Annex 2 to the convention. During the 4th session, we have the revised single negotiating text. These are 2 important sessions. The 3rd and the 4th session of the convention are extremely important as the debate was prevailing over the fact that a group of states wanted to maintain the continental shelf as an independent element, and others wanted to subsume the continental shelf within the new space that we now call the exclusive economic zone. The interesting part during this 4th session is that the continental shelf remains in place, and Canada presented a proposal that already provides the first draft, the basis for the discussion of the production of Annex 2 to the convention, specifying the several aspects, duties, obligations of the Commission, procedures to be followed, and the composition and functions of the Commission. This slide moved a little bit faster than I would have wanted. I am not moving the slides myself. This is something that happened during the 6th session in New York, where a request was made by the 2nd committee to illustrate what would be the potential effect of applying some of the formulae that were being discussed. This is still very early. This is still the 6th session. And as a result of that request by the 2nd committee, the Secretariat requested the Lamont Doherty Oceanographic Institution to actually compute this map and put the lines on the ground that would allow the conference to get an idea as to how far some of these limits would go. This map was heavily criticized a year later. There was a study called the IOC Study on the Implications and Difficulties of Preparing Large-Scale Maps, like the one that you saw. By the way, the main conclusion, one of the main conclusions of that map was that there would be 35 submissions and no more. 35 states would make submissions to extend the continental shelf. Well, during the 8th session, the International Oceanographic Commission produces another study that relates to the implications and difficulties of preparing large-scale maps like the one that you saw before. And they have a very damning, they make a very damning judgment of the lines produced in the previous map. They criticize the scale, they criticize the generalizations, they point at errors, material errors made in the preparation of that map. However, this study did not produce a new and independent map. It was a written study analyzing, discussing in great detail some of the main challenges that would be faced by implementing the provisions being drafted at that time. So what really remained in the minds of many delegates in the conference was the map that indicated that there would be about 35 submissions made by states, and that those limits would be, if not exactly the ones provided in the map, and to take into consideration the rush with which it had been prepared, which was only 1 year, it nevertheless would serve as some kind of an idea, some kind of guidance as to, for illustrative purposes, how far the continental shelf could go. The other element that happens during the 8th session is the proposal made by the Soviet Union to introduce once again the element of an annex that would more specifically describe a number of issues that had been already included in the Canadian proposal before that. During the 8th resumed session, the United Kingdom took the Canadian draft and basically made a few changes on it, but the framework was basically the same. And in the 9th session, in the informal composite negotiating text, we already find a good approximation of what is likely to become Article 76 and paragraph 8, which refers to an Annex 2 that in this draft does not yet exist. The draft will exist next in the resumed 9th session, where paragraph 8 refers to an Annex 2 to the convention and actually introduces the annex. Between 1980 and 1982, particularly during 1981, during the 10th session, only editorial changes were made. There were a few terms changed, but fundamentally, Annex 2 remains the same. In 1981, the Secretary General also prepared a report on financial implications of the convention, including an assessment of the cost of staffing the commission and its subcommissions. I want to clarify something very important before we move on to the next slide, and that is the following. Some of the key provisions existed from the time of the first proposal made by Canada early on during the third conference on the law of the sea. You will recall that the drafting was not complete on Article 76. The sediment thickness rule had not been incorporated. The Soviet proposal to include the 2,500 meter isoath had not been included. Nobody knew what a submission could look like, but the Canadian draft already inherited into the subsequent drafts made by the United Kingdom and by the conference, particularly in NG6, the negotiating group 6, and all the way to the Convention on the Law of the Sea, several key provisions, including, among others, the fact that the states would defray the costs of members in the Commission. And that is a big question at the present time, simply because they had no idea how a submission would look like, what would be the kind of experts that would be required. So let us start with our commentary here and look at Annex 2, Article 2 of Annex 2 to the Convention. Paragraph 1 says that the Commission shall consist of 21 members who shall be experts in the field of geology, geophysics, or hydrography. Well, the commentary that I make in this regard is that the second Evensen Group proposal made during the third session included a footnote, which included a provision for the participation of legal expertise in the Commission. This is a group of scientists working fundamentally in a legal framework. And that draft took into consideration that there would be perhaps some aspects of international law and law of the sea in particular that could assist the work of the Commission. They also contemplated a role for the Commission in dispute settlement procedures under the new convention. But the paragraph that arrived at the convention did not include any provision for any kind of communication or interaction between the Commission on the limits of the continental shelf and the International Tribunal on the Law of the Sea. In that sense, the Commission is not entitled under the convention to seek an advisory or legal opinion from the International Tribunal on the Law of the Sea. In an analogous form, the tribunal is also not explicitly entitled to request advice from the Commission, but that is another interesting aspect of lack of communication between institutions created under the convention. The meeting of states parties sought clarification and strict guidelines from the Commission vis-a-vis cases involving submissions in case of dispute between states with opposite or adjacent coasts, or in other cases of unresolved land or maritime disputes. The Commission had to respond to that request that came from the meeting of states parties, and as a result of that, Annex 1 to the rules of procedure that considers those situations and also provides for other avenues of cooperation by means of joint submissions and partial submissions was created. But it would have been, in my view, highly desirable that a draft Annex 1 that is going to do with fundamentally legal issues related to disputes would have received a legal opinion, an advisory opinion from a legal body such as the International Tribunal on the Law of the Sea. Finally, the comment that I make in relation to the professional background of the Commission is that not all members elected by the meeting of states parties have actually been experts in the fields identified above. We have had other professions other than geologists, geophysicists, or hydrographers who have actually been elected by the meeting of states parties. The next article and paragraph that I wish to comment on is Article 2, Paragraph 5. This is a very important aspect that I was requested by the organizers to address. And of course, it contains the very controversial part that was introduced in the proposal made by Canada, then taken by the United Kingdom, and then gone into negotiating group 6 in the latter stages of the conference to ask the states that nominate the members and the members that become elected members of the Commission to defray the expenses while in performance of Commission duties. The study requested by the second committee in June 1977 and delivered in 1978 was only a map ever produced throughout the conference to portray the potential geographical scope of the extended continental shelf. And it showed at the time the notion that there would be only 35 submissions. The burden of defraying expenses of members of the Commission, if the submissions had been 35, in fact, would have been completed by now. The Commission has already looked at the 35 submissions, but the Commission has not received, through the Secretary General, 35 submissions. This was one of the most grave miscalculations in the consideration of the implementation of Article 76. As my colleague Rajan, Dr. Rajan has already mentioned in the previous presentation, we have 85 submissions. I would add to that 7 revised submissions only to this date. And there are other submissions that are likely to come from other states that have not made them and states that have not ratified the convention yet or have not acceded to it yet. My reading of this situation is that both the Secretariat and delegations of the conference did not ever have a full understanding, and they could not have had it, about the breadth and scope of scientific and technical data, effort, and cost entailed in both the preparation of submissions by states and the consideration of submissions by the Commission. This was each submission is a much larger body than the one map prepared in a single year by Lamont Doherty. The difficulties encountered by members of the Commission from developed, and I want to emphasize this, developed and developing countries, with an arrangement provided in this paragraph of Annex 2, is described in the presentations given in the open meeting of the Commission held on the occasion of its 20th anniversary on the 10th of March 2017. And they are documented in numerous reports and publications sent to the meeting of states parties since the year 2000 until 2020. The latest version, the latest document that describes the consequences, the difficulties faced by Commission members and the states that nominated them. And I insist, not only coming from developing countries, but from developed countries as well, is clearly indicated in the publication that was made available to the meeting of states parties to have been held this year in 2020, which unfortunately could not take place. The publication is S+3011, for those of you who are interested to see how grave the consequences of this paragraph is in the performance of the duties. It is important in the context of this pandemic to ourselves be concerned about the health of the members of the Commission who go to New York to work under those circumstances without any medical insurance, for example. Article 3 establishes the functions of the Commission to consider data and information on the one hand, but also to provide scientific and technical advice if requested by the coastal state. The commentary that I make is that provision was so general in nature that the CLCS was compelled to develop further the procedure to provide advice to states in Rule 55 of its Rule of Procedure. It created a standing body in order to consider the request by states. It also limited the number of members of the Commission who could provide advice to a single state and a few other provisions. The interesting aspect to highlight here is that this is an avenue that has not been used by states. There, to my knowledge, for 20 years, and I believe that to be the case, according to the statement of the chairman up to now, there has not been a single request for assistance by states through this channel, through the official channel of requesting the Commission to nominate a member to provide advice. Instead, what has happened consistently is the states themselves invite a specific member or former member of the Commission to participate in the preparation of the submission, and that is another avenue in which it was actually happened. The commentary that I wish to make in relation to Article 4 is the following. There was a sense of urgency in the Convention to establish the boundary between areas of national jurisdiction and the area. There was an urgency to allow states to exercise their rights of exploration and exploitation of natural resources in the seabed and subsoil in areas of extended jurisdiction. But there was also urgency to see the International Seabed Authority to begin to put in place the mechanisms that would allow it to issue exploration permits and eventually exploitation resources as well. That is why it is said that this should happen as soon as possible. The submission should be made as soon as possible, but in any case, within 10 years of entry force of the Convention. Of course, the commentary that I make is that The deadline based on it was made on an evident underestimation of the breadth and scope of the scientific and technical effort and cost entailed in the preparation of submission. Many states could not prepare submissions within the 10-year period, and some others had started actually before the convention was enforced for them in order to begin the preparation of the submission. The notion that the short deadline would provide certainty to the International Civil Authority and states to act in the short period after entering into force did not materialize. The deadline is dead, to put it mildly. The meeting of states parties already extended the deadline due to difficulties, particularly to small island states. There have been also postponements, very sadly, due to territorial and maritime disputes, though those submissions are frozen in time, and the Commission has no ability to intervene and issue recommendations based on the provisions of Annex 1, as the resolution of those disputes are in the hands of those states. But obviously that delays as well the certainty that was sought for in such a short deadline to have submissions considered as soon as possible. And if to that you add the workload of the Commission due to the number of submissions and the amount of information, of massive information that is included in many of these submissions, then you understand that this is a process that is going to take a lot longer than it was anticipated. And that is without taking into consideration the delay now imposed on the work of the Commission by this pandemic, which is delaying at least a year, perhaps longer, the consideration of submissions in New York. I do not see how the job of the Commission may be finished in less than 15 or 20 years from now, keeping into consideration that we have 35 recommendations and we're going to have in excess of 100 submissions. Simply the numbers do not add up at the present time. Something will have to be done to allow the Commission to work more efficiently. Annex Article 5 of the Annex 2 contains perhaps the most controversial provision, in my view, in the entire convention, not only in Annex 2, but in the convention as a whole. And the part of Article 5 that I want to point out is that one that says that any Commission member who has assisted a coastal state by providing scientific and technical advice with respect to the delineation shall not be a member of the subcommission dealing with—
Dr. Carrera, you too much talk. So 4 minutes later, your talk will be finished, okay?
Thank you very much. I am almost done, Dr. Park. But has the right to participate as a member in the proceedings of the Commission. Well, that this is the most controversial provision in Annex 2 because it places coastal states which make submissions and have members in the Commission in an unequal status vis-a-vis coastal states that make submissions without members in it. The rules of procedure cannot contravene the provisions of the Convention, and therefore we could not eliminate the participation of those members. And a code of conduct has to be adopted by each member to participate during the consideration of their own national submission. And I will stop here, Mr. Chairman, just to point out that since the first article, since the first proposal draft, it was already considered that a member of the Commission who is a national of the state who makes the submission would participate in the plenary at the end. That, of course, creates a situation of inequality among the consideration of submissions for states. So for that reason, at this point, I finish my presentation at this time. The rest of the presentation will be part of the proceedings, and I stop here. Thank you very much.
Thank you very much. And then we move to the next speaker. Last one, the Dr. Warwick Goulet. Just he say something. Okay, so you're going to have your your program now. Okay, good. Goulet?
Thank you. I think my presentation is all ready to play. Is that able to be? Is the tape able to be played?
Good. Okay. We look at your vision first. Okay. Good.
Hello, I'm Warwick Gullett from the University of Wollongong in Australia. I thank KMI and the Ministry for inviting me to participate in this conference program again. In this presentation, I'll be talking about exploitation of the deep seabed. This is becoming an increasingly important area because in recent years there have been rapid leaps and bounds made towards technical and commercial viability of extracting mineral resources from the deep seabed. This presents challenges to the UN's International Seabed Authority, the ISA, which is a body entrusted with developing the legal regime. And in doing so, it must take into account a range of views. And it has the ability and indeed the responsibility to develop new standards in international law. I will first briefly set the scene of the challenges that ISA faces and outline some of the competing interests it must take into account. The task the ISA faces is formidable, but it has demonstrated initiative and innovation in how it has progressed the development of regulations across distinct but interrelated topics. And I think the approach it's taken to developing the regulations will be influential for the development of international law in other fields. The overarching challenge the ISA faces is to balance environment and development. This conundrum is something that is faced in all domestic environmental law regimes. Environment balanced against development. But here it is taking place in a unique area that we know of as the area beyond the limits of national jurisdiction, and therefore one in which the consensus approach to international law is crucial. The expectation that the ISA balances environment and protection is evident from the Convention itself and from the 1994 Implementing Agreement, but also in more modern expressions such as the UN SD Goal 14. The ISA's approach is also one that must be predicated on guarding against disaster, the precautionary principle writ large. This doesn't just mean developing sound planning mechanisms, but also making sure there are sound financial mechanisms in place in case something goes wrong. And that if something does go wrong, the right actors will be held liable and will take the right action. There is little known about the resilience of the abyssal plain to human interference, but one thing we can be sure of, there will be no easy, quick fix to environmental damage of the area. And also, we shouldn't be looking at the area as barren and devoid of environmental value. There is increasing understanding that deep seabed environments are rich in biodiversity. The ISA also needs to consider how its regime interacts with other legal regimes for other uses of the marine environment in high seas areas, such as the laying and maintenance of submarine cables, the freedom of navigation, the freedom of fishing, and the conduct of marine scientific research. This is in the context that contractors expect to have security of tenure for their contracts to give them the necessary confidence to undertake their very expensive activities. There is obvious potential for interference between activities of mining contractors and these other uses of the marine environment. So how will this potential conflict be minimized or avoided or managed? Exploitation contractors cannot be permitted to limit the exercise of high seas freedoms enjoyed by other users. However, neither should high seas contractors be expected to automatically yield to the exercise of those other high seas freedoms. Rather, what is needed is a pathway for coexistence must be forged. The area is the deep seabed, the ocean floor and the subsoil beyond the limits of national jurisdiction, meaning it is those areas beyond the outer limit of coastal states' continental shelves. Companies that are supported by sponsoring states have conducted extensive exploratory activity in areas designated and approved by the ISA across the three main types of minerals in which there is commercial interest. These are the polymetallic nodules, the polymetallic sulfides, and the ferromanganese crusts. Each of these is located in different environments, and the techniques needed to extract them are very different. The high level of interest in extracting such resources is due to rapid developments in deep seabed mining technology and overall rising prices for commodities such as copper, nickel, cobalt, and manganese, as the world strives to enhance battery capability and find new renewable energy technologies. So there have been more applications for contracts to the ISA for exploration. Currently there are 30. The general legal environment in which the ISA operates is unique. It is charged with heavy responsibilities over a large, yet incompletely defined area, the legal status of which is different from any other place on Earth. Now, while the definition of the area is clear, being the areas beyond national jurisdiction, it is actually very difficult to locate precisely the boundary between the edge of national jurisdiction and the start of the area, because we're dealing with complicated deep seabed environments. Also, where geomorphology allows, coastal states may claim an extended continental shelf beyond 200 nautical miles, and that involves a comprehensive and also very lengthy process of having those submissions considered by the Commission for the Limits of the Continental Shelf. Now, it is expected when the ISA gets to the point of making exploitation contracts that it must be in areas well within the outside limit of the area to avoid the potential for conflict between mining contractors and the sovereign rights of the adjacent coastal state, and to avoid the prospect for transboundary harm. Yet happily, this is not expected to be a significant problem, because so far the information is that the locations where the minerals are tend to be well beyond continental shelves. Nevertheless, earlier this year, the Secretary General of the ISA, Mr. Michael Lodge, formally requested all states to deposit charts or a list of coordinates of the outer limit of their continental shelves. So far, only 8 countries have done so. The area is also subject to a unique but imprecise concept of international law known as the common heritage of mankind. So the ISA must give legal effect to this, but what does it mean? Can a meaning be discerned for this context, and if so, would that meaning garner universal acceptance? So it is evident that the ISA faces considerable challenges. Its governing priorities can easily be seen to be in tension with each other, such as the goal of developing strict environmental protection standards and also developing streamlined and cost-effective regulatory approvals. They could also be open to divergent interpretations, such as whether the common heritage of mankind concept predominantly envisages financial surpluses flowing to developing countries with greater weighting to the least developed countries, or whether the concept also embodies as a core component the idea of environmental preservation. The ISA also needs to navigate difficult diplomatic waters, because numerous countries are involved in these preparatory exploration activities, and also over 70% of the countries in the world are currently classified as developing, and all of those countries would have an interest in due course of being financial beneficiaries of deep seabed mining. But we also have some odd situations. So for example, there is China. So China is a large state that is keen to maintain its status as a developing country, but it is also one that has secured 5 exploration contracts and is poised to be the largest financial contributor to the ISA. So China thus finds itself in a position of being a beneficiary state of the common heritage of mankind concept, but also a state that is at the forefront of technological and competence and expertise for deep seabed mining. So such duality for developing states was not envisaged during the drafting process of the convention. And finally, the ISA is committed to working in a way that is transparent and inclusive, and that's a great goal considering its work is of interest to all states and many stakeholders and interest groups. Now, this is just a short slide of a couple of the provisions that are important for the ISA for its environmental mandate, and especially Article 145, that it can undertake unspecified but necessary measures for environmental protection. Now I want to focus on a few of the areas currently being addressed by the ISA. So its current most significant task is finalising the exploitation regulations, which they had envisaged would be finished in 2020, but it looks like that will be later than that now, together with the parallel process of the Legal and Technical Commission developing guidelines and standards. So let's look at some areas where there is a divergence of opinion among ISA members. This discussion is drawn from the current 26th session of the ISA and the draft exploitation regulations. And helpfully, the ISA has released the draft exploitation regulations, but also in an annotated way that has all of the various submissions received for textual amendment to those draft regulations. So a long way short of having the finalised regulations, but it shows some of the issues of importance to member states. And one of these is regional environmental management plans, something that the ISA is committed to, but is not expressly authorised in the Convention, but it could be considered to be a necessary measure under Article 145. So the purpose of regional plans is to provide greater awareness across a region of all the issues involved to facilitate decision making for mineral extraction. So they would enable regional specific objectives to be identified, to be able to work out the carrying capacity of the region, to be able to assess cumulative impacts, and try to manage conflicts with other users and other contractors. So they'll provide a sort of a level playing field for contractors across the whole region, and the contractors are of course in competition with each other. One regional plan has been created for the large Clarion-Clipperton zone in the Pacific. Others are currently in development. Now they are a source of debate within Council. Some members have submitted that the provisions of these plans should be binding, and that fully developed and agreed plans should be made a condition for the approval of any plan of works for exploitation. Others have submitted that the plans are not legally binding instruments, and there needs to be more discussion about how they integrated or referenced in the exploitation regulations. Now, for example, there's one submission that says an application for a plan of work should not even be considered unless and until a regional plan is in place, and also that the Commission should not approve a plan of work if such approval would undermine a regional plan. Now, this is a noble goal, but we can see it could be a little bit difficult to implement, like what is the standard for undermining or contradicting. So this is showing one of the important and sensitive issues being worked through by the ISA. There is also a concern that's been raised that regional environmental management plans should not be misused so as to block plans of work. Earlier this year, the ISA Council tasked its Legal and Technical Commission to develop further guidelines for regional plans in a way that adopts a standardised approach. Environmental principles. The negotiation process for the exploitation regulations has involved considerable discussion among a few of the members about environmental principles and whether and how they should be referenced in the exploitation regulations. So there's been discussion of the polluter pays principle, then the ecosystem approach, but most discussion has centred on the precautionary principle or approach. Now, the precise contours of the precautionary principle remain elusive, but it can be effective if it's fleshed out in detail in either international instruments or other agreements. And it can also have broader influence where it is accepted as a sectoral norm for dealing with ever-present uncertainty. And this seems to be the case with the work of the ISA, where there's been considerable constructive debate about how to operationalise the principle in the regulations. So, for example, there have been submissions that there should be express mention of precaution, that precautionary methodology is specified for the process of conducting environmental impact assessments, that contractors, when they submit their annual reports, that they need to address matters at the heart of the precautionary principle, that test mining should be conducted prior to any approval of a plan of work to give greater confidence about the environmental impacts of that activity. And there's also been submissions from some states and NGOs, and in particular, let's say Germany, saying that the principle should be interpreted more broadly than the current popular version of the principle, which is drawn from the 1992 Rio Declaration. And Germany is, of course, where the principle originated. Another area where the ISA is spending a lot of time working on is addressing the problem if something goes wrong. So what if there is a catastrophic accident that results in damage to seabed resources or pollution to the environment more generally, or damage to equipment of mining contractors? Who will pay compensation? Who will fix the environment? The starting point is the Law of the Sea Convention. It has provisions dealing with liability for environmental damage. However, as noted by the Seabeds Dispute Chamber in its 2011 advisory opinion, there are liability gaps because the Law of the Sea Convention has liability, but fault-based liability, meaning you only pay if you've done something wrong. But we can envisage circumstances in which there is environmental damage that happened accidentally, therefore without fault, or happened in unforeseen circumstances, therefore it couldn't have been guarded against. So to supplement this liability regime, it seems there needs to be a supplementary financial mechanism, a fund, to be able to fix things when things go wrong. So this then raises a further array of questions about what is the source of the funding, who should administer it, what should be the threshold for triggering application of the fund, and particularly how the fund money gets into the fund. So should contractors have a flat fee levied against them, plus perhaps a further amount based on the amount of revenue they're deriving from the mineral resources. Now, earlier this year, the ISA commissioned a study on such matters that was recently completed, and it's expected, or I expect that the ISA will, in the coming period, propose a framework to establish a compensation fund. Now, conflicting users. So, even though deep seabed mining will be taking place in remote areas of the world's oceans, it's going to take place across a large area, and it will involve a lot of equipment. It will involve, in most cases, moving the minerals up to the surface and then transporting them to land. So that's taking up a lot of activity, a lot of area that could conflict with fishing, with navigation, and of course submarine cables. So the ISA has spent considerable time trying to work through these type of conflicts. In particular, hosting workshops, bring together actors from the different industries to have better awareness of each other. And to try to work for identify practical solutions where mining, for example, and submarine cables would need to be in similar areas. So the basis for this coexistence is the Law of the Sea Convention, saying each activity should have either reasonable regard or due regard, their equivalent, to each other. And what we're now seeing with the work that ISA has done is that in the proposed draft regulations, this is being fleshed out a little bit. This is not accepted, but these are some of the issues currently being debated. For example, there's a proposed expectation that contractors, when they submit a proposal for a plan of work, that they've gone to some effort to identify any submarine cables or planned submarine cables. They've identified areas for intense fishing activity, or maybe where marine scientific research would take place, and they've identified sea lanes that are critical for international navigation to try to work out where they do their activities that would have less impact on these other users. There's also a proposal for Regulation 15 that it would state that there wouldn't be approval for a plan of work for exploitation if it would cause undue influence with the freedom to lay submarine cables. To a degree that makes sense and could be consistent with the convention, but still a difficult standard of undue influence. And there's also a proposal that for contractors, when they've undertaken their work, that they must notify the ISA of particular events, that this should include if there's been significant contact with equipment from marine scientific research. Okay, so some other issues are quite briefly. The ISA has supported the approach of having an outcomes-based approach for environmental assessment. So rather than have environmental assessments written in a way where there's incredibly long and detailed technical standards, that they're more goal setting that's going to be standard across for all contractors. So this seems to be, even though less specificity, this seems to be a good approach in these circumstances where there are operators coming from many different countries with many different sort of domestic environmental law regimes, that this would enable them all to meet the same standard but give them some flexibility and ability to use innovation to how they meet those standards. So that's a significant issue from the ISA. There's the forever issue of developing countries that are heavily recognised in the convention and how to give effect to their interests in the mining context. So, for example, there's currently a proposal in the regulations where the regulations for exploitation would be for 30 years, But in the case of a contract for a developing state, that a contract could go for another 20 years, out to 50 years. So that's an issue for the ISA to consider. Should developing countries have that greater length of time for their contracts? And if so, then that would make it even more critical how to determine if a country is developing or not. And of course, there's a range within the developing spectrum. There's also an issue that was foreshadowed by the drafters of the convention about land economies. So if there's seabed mining for certain minerals, then all those minerals is coming into the market, then that could affect the market price and market share of developing countries where perhaps a large percentage of their annual revenue comes from exploiting those very resources from land. So there's a potential for seabed mining to have economic consequences for developing countries that rely on exporting the same products. So the ISA Commissioner report on this important matter that was completed in 2020 in May, and it's noted a number of important issues and the need for further work. Force majeure. This is a standard clause in contracts, but now we need to consider whether they're appropriate to cover something like COVID-19. Is something like that we weren't thinking about last year? Is it a force majeure? And in which case, who determines it? At what time does it start? And what's the full effects of that? Okay, so my final thoughts are that the ISA has adopted a very comprehensive, inclusive, transparent approach to developing regulations that's commendable. The scale of the work that it's doing, I think, reminds us of the scale of the work that was involved in drafting the convention itself in UNCLOS 3. It's really remarkable what it's doing. We can expect high standards. It can develop high standards in the environmental assessment regime. We can see the ISA sort of expanding in more an informal capacity, its role facilitating avoidance of conflict with other users outside mining. And an important area for us is to assess the approach ISA has taken to develop the law, assess its powers, the way it's been developing detailed procedural and administrative rules, the approach by which it's done that, and the manner in which it's being checked. And I think the openness that it's undertaken is something that will be followed by others in other areas of law, international law, as they develop. Thank you.
You have a good lecture. So anyhow, anyway, we are very late for this time schedule. So now going on the Dr. Woo Kyung-chik is professor of Kwangwon National University, and he has you have the mic, okay?
Yeah.
You have, okay. Good.
Thank you, Chairman. Good afternoon, ladies and gentlemen. It's my great pleasure to be here. I'm a marine geologist, and I'm not really familiar with law, so I'll probably concentrate my talk on the scientific issues. Dr. Carrera summarized very nicely about the past activities and current challenges about CRCS, and I'm not going to mention about it, but the other two speakers dealt with various marine resources beyond the limit of EEZ, 200 nautical miles. And as mentioned by them, there are various potential and ongoing mineral resources in this realm. Despite of scientific research past a few decades on these resources, there are still a number of challenges and threats before exploration. Even though Dr. Rajan pointed out that he stated that it may not be happening, in the near future, I think it is expected that there will be a dramatic increasing demand for exploration and exploitation in the future. And it is absolutely necessary for ISA to get prepared more specifically. So I'd like to approach this matter in terms of nature conservation and the heritage concepts. Exploitation of marine resources in deep seabed have been mainly limited to scientific investigation yet because they were not economically and technically feasible. However, recent advances in marine technology and scientific knowledge are approaching to the state that the exploitation will not be just an idea. Scientific technology will overcome the unpleasant conditions for exploration and exploitation. Recently, most available resources, such as hydrocarbon, are already actively explored beyond EEZ where shelf areas are broader, such as Canada, as Dr. Rajan pointed out, and in several deep sea areas in the world. So my first comment on water, the marine contamination issue. As we are well aware, marine environments are very susceptible to water contamination because active exchange of water through surface and deep currents take place everywhere. In addition, it is well accepted that surface and deep sea currents are all interconnected as a loop. We call it meridional overturning circulation. Not like terrestrial environment, marine ecosystem include fewer niches than land due to this globally interconnected oceanographic setting. This means that development of marine resources can make dreadful threats to ecosystem. Once marine environment is contaminated, there's no way to restore back to the original state. Because exploitation method would be different, I think there are EIAs, environmental impact assessments, and the regional environmental management plans, as pointed by Dr. Guret, should be separately developed and prepared for each type of non-living resources of the seabed. Several points were already made by the speakers about this issue, but I think I must emphasize them again due to complex and interconnected nature of oceanographic processes. Marine dredging will be operated for phosphorites, cobalt niche ferromanganese crust, and nodules, influencing on the ecosystem for sessile epifauna and possibly infauna, which may be applied to also polymetallic sulfides as well. The exploitation of hydrocarbon as well as gas hydrates should involve deep coring into the seabed, which may disturb large marine surface and subsurface ecosystem. This means that each site associated with a certain resource displays different oceanographic and geological setting respectively. I think it is therefore necessary to consider potential environment, oceanographic, and geological changes very, very carefully before making a decision of exploitation. Now the second point is about the marine heritage. Despite the sovereign rights over the continental shelf under Article 77, natural resources beyond EEZ should be treated as a natural heritage of humankind under Article 146, as Dr. pointed out. And it was interesting to hear that Dr. James Kraska also mentioned about this this morning. This concept has significant implications. After the evaluation of geoheritage values in terrestrial environments, geoheritage conservation should be focused on the best representatives and rare and unique sites. This means that some of the best geoheritage sites for these potential exploitation areas should be evaluated before geoheritage assessment, before exploitation. Even though it may involve long-term, tedious scientific research. For example, hydrothermal vents with polymetallic sulfides as well as methane seepage sites on the seafloor are intimately associated with very special ecosystem, and it was a huge discovery in this century that when we found the deep sea fauna related to the methane vent. Everybody was excited, and we have to conserve the best site for future generations. There can be several representative stages of community evolution on these sites, which should be conserved for future generations as well. Recent concept for World Heritage Geoheritage Site were changed recently to include marine site. That means that I was in IUCN meeting last year, and we actually added the topic marine system because we are not really taking seriously about the marine heritages yet, but we are beginning to realize that there are certain marine heritages to be protected for future generations. Thus, it is necessary to make a scientific research for geoheritage assessment during exploration based on scientific results. In Korea, we have a procedure that before constructing a large building, you have to investigate if there is any significant archaeological remains or other historical sites, whatever. So it's the same rule should be applied to the marine system. We have to protect the most precious site, which has the highest heritage values. So exploitation should take place from the least recognized site in terms of geoheritage values. Special guideline by ISA needs to be established in this respect. And by doing so, we may be able to achieve the UN SDG number 14.
So
and yeah,
too much. So,
yeah, I just have a short. I'd like to have a short comments from Dr. Rajan and Dr. Goulet. I mean, what do you think are the best way, but the best way to approach this problem? Thank you.
Yeah, thank you. Thank you, Mr. Chairman. I think I have 7 to 8 minutes to talk here, not long though. So especially when I try to deliver something, always in seminar. So I'll try my best. As you know, we have 2 kinds of concepts here. The first one is the outer continental shelf. It is this. Outer continental shelf refers to areas lying beyond 200 nautical miles. It falls within the jurisdiction of a state. However, its submission is required. The CLCS, Commission on the Limits of Continental Shelf, to confirm rights in the outer continental shelf. On the other hand, the area refers to the area lying beyond the national jurisdiction. Shortly, we call it ABNJ. It means seabed and subsoil non-living resources administered by International Seabed Authority, shortly ISA. I'll focus on the area today. The ISA, as Professor Goulet mentioned, has been working very hard to finalize draft regulations on the exploitation of mineral resources in the area. They are mainly designed to well administer the future seabed mining within the area. Then why does it matter? Although exploitation is not available commercially right now, there are some big major private developers to take part in seabed mining. So it is a good time for us to deeply consider some of the matters from now on. Self-question, is exploitation code of the area hard topic? Yes, it is definitely. I've said some of the problems to be considered. Some of the difficult problems concern, firstly, distribution of profit, that is profit sharing from the development of the area. Secondly, environmental protection versus developing deep seabed mining. Now, first, distribution of profits by deep seabed mining in the area. It is a very difficult question, also difficult and controversial as well to determine how to distribute the developers' profits from exploitation. So profit sharing is based on, as you all know, the common heritage of mankind. That is, deep seabed can be subject no jurisdiction of any country in the world. So it is unavoidable that the exploitation of the area naturally concern the issue of royalty. So I say basically deep seabed mining is tough and very dangerous job. So it is very difficult to get successful commercially. So with regard to profit sharing, step-by-step approach is to be considered. That is, first stage, at the beginning of the exploitation, desirable thing is to impose the royalty rate as low as possible. And second stage, as the developer's profit goes high, then royalty rate will need to rise. Now, secondly, with regard to the issue of environmental protection versus developing deep seabed mining, this is another hard topic with regard to exploitation in the area. I understand that ISA is to operate with dual mandate. First one is promoting the development of deep seabed minerals. Secondly, protecting the marine environment, that is ensuring sustainable development. I think the dual mandate of the ISA is challenging and competing somewhat conflicting mandate. Although I will need to see ISA's work, that is, I need to see how the ISA will finalize full details of the way it will manage the environmental aspects of seabed exploitation. I'll take an opportunity to make some comment on some of the points briefly here. It is always important to make a balance between the exploitation of the seabed minerals and the protection of the seabed environment. The question is how? My thoughts are here. Some of the important steps must be made in advance on a scientific basis. So baseline studies about deep sea species, where deep sea species are, in what species are there, and scientific research to be carried out by the developer's side. And then establishment of marine life protected areas must be considered as well in order to mitigate the impact of deep seabed mining. Let's think twice, detailed environmental impact assessment as well. This is to meet the principle of precautionary approach. So does the ISA, so lastly, does the ISA need to be supervised by the international community? Yes, I think so. Like Professor Gula says, I suppose ISA would work transparently. I think ISA could become an agency of concentration of some power, though. So desirable thing is to have oversight by some of the independent bodies to try to reach the goal of more transparent and sustainable development with regard to deep sea bed mining. The example is this, to make some sort of administrative law for governing rule of law. That's that's it, thank you.
Okay. Thank you, Mr. Hong, and then Mr. Park Young, you say something.
Thank you, Chairman. Actually, I have prepared for discussion for two issues, and I have two questions for Professor Goulet, but due to the time constraint, I will talk about only one issue, and I raise only one question to Professor Goulet. Are you okay? Yeah. Yeah. Article 76, paragraph 1 provides that the continental shelf extends to the outer edge of the continental margin or to a distance of 200 nautical miles. Paragraph 2 through 7 of the Article 76 set forth the detailed rules for determining the continental shelf's precise outer limits in those areas where the continental margin extends beyond 200 nautical miles from the coast. Now, I would like to discuss one issue regarding the legal questions on the outer continental shelf. The issue is related to the legal status of the third party to the UN Convention on the Law of the Sea. The International Court of Justice in the territorial and maritime dispute case between Nicaragua and Colombia in 2012 has declared Article 76 of the UN Convention on the Law of the Sea to have the status of customary international law. The United States is at present not a party to the UN Convention on the Law of the Sea. It is using Article 76 to determine its continental shelf limits and considers the provision to reflect customary international law. Article 76, paragraph 8 of the Convention provides procedures to extend coastal states' continental shelf beyond 200 nautical miles from the baselines. To extend its limits of the continental shelf beyond 200 nautical miles, the coastal state should submit the relevant information to the CLCS commissions on the limit of continental shelf. Then the CLCS shall make recommendation to the coastal state on the outer limits of the continental shelf. The limits of the continental shelf established by the coastal state based on the recommendation of the CLCS shall be final and binding. In this regard, my question for Professor Warwick Goulet is as follows. If a third party like United States to the conventions wants to extend the limits of their its continental shelf beyond 200 nautical miles, does the state has the legal obligation to submit the relevant information to the CLCS? If the state, non-state party to the UN Convention on the Law of the Sea extends the limits of the continental shelf beyond 200 nautical miles without the recommendation by the CLCS, what is the legal implication under the UN Convention on the Law of the Sea? Is it null and void? Thank you for your attention.
Okay, thank you. Okay, then the time almost 5 minutes over. So shall we finish this second stage of the articles to the presenters, or what are you going to do? So at least Professor Park, you have the question about Mr. Goulet, okay? Good. Okay, Goulet, you have a very short you short answer about that, okay? You have it for that.
Okay, thank you very much, and thank you to our excellent discussants. So I'll do this as briefly as I can. So going first to Professor Wu, and it was very good to hear your comments, particularly about the common heritage, later on about the geoheritage assessment, and thinking about whether there should be a preservation of these different areas, and what is the best way to address the problem you asked, essentially balancing environment and development, and looking at the common heritage for mankind concept, going also to future generations. So that's a great question. The real heart of the problem faced by the ISA, balancing environment and development, and how to deal with the common heritage of mankind. I think what is necessary is for there to be further discussion and try to get broader agreement about what are the components of the common heritage of mankind principle. And you know, we see in it's in Article 136. I mean, can't quite see it. Article 136. Of course, there's no definition. Hardly any terms are defined in the convention, other than Article 76, which my friends on the panel are experts in. But Article 136, Common Heritage of Mankind, we don't have a definition. So I think it's useful to have a continued discussion, try to get a broader discussion and views about what it actually entails. Because I think a problem is most of the attention is focused on the revenue sharing aspects, that the common heritage of mankind concept means the deep sea bed is owned by all of us across the world, and revenue should be shared, especially towards developing countries. But that's correct, but that emphasis tends to take us away from the idea that the area has been willed to everybody, including future generations. So your focus on having conservation areas, assessing those first, putting them aside before there's exploitation is very important. So the ISA has been starting work and discussion on this issue, but I think more needs to be done. And certainly it's been doing some things along the lines of setting aside areas. So there are preservation zones to be established, representative areas to be set aside. So it has done quite a lot of work here, and it'd be good to see how that unfolds as exploitation regulations get finalized. And Professor Bang was mentioning about the process of, let's say, lawmaking of the ISA, and whether the ISA should be supervised by the international community. It doesn't need more oversight due to the detailed administrative regulations that it's developing. Well, I say sort of maybe sort of yes and no on that point. I mean, we can look at, yes, the importance of the ISA's work, but we must remember that it is sort of the body to bring together all the member states. It's all state parties to the convention are those making the decisions, influenced and assisted by the ISA, but it's actually essentially the member states, which are all 168 state parties to the convention, that are making the decisions, not simply the technical and experts of the ISA. So we need to sort of recognize they are in a difficult situation. They're not simply making up the rules without deep and wide consultation. But I'm certainly interested in the question about how we evaluate the lawmaking powers and functions that we see of the ISA. And Dr. Young-Kil Park, that was a really interesting question, a very specific question. Let's focus on the USA. It's not a party to the convention, but it's going down the path of saying it has an extended continental shelf claim. Does it need to go through the CLCS process? I haven't looked at this question. I think it's a fascinating question. I would imagine it would need to be a state party before it lodges information in a formal way, just like all other member states. And I think it's encouraging that the US is doing this, because we're all waiting with champagne on ice for the US to join us in the convention. So this just could look like it's doing smart preparatory work for one day becoming a party to the convention. And of course, there's a lot of work that has to go into making a CLCS submission. So I think it's a good sign that the US is taking this approach. And of course, there are a lot of people in the states who want the states to ratify the agreement. Then finally, your question is, so what if the US, let's call it the US, starts behaving in a way that does have an extended continental shelf claim that hasn't gone through the CLCS? Is that going to be null and void? I think that's an excellent question. We know the convention says the limits need to be confirmed by the CLCS. That's all it's saying. It's about being confirmed. And I would imagine the problem would only arise if the US does this and actually acts in a way in reliance on its purported extended continental shelf claim that hasn't been confirmed by the CLCS, and therefore we have a conflict with another state, and then we have to go through the dispute resolution process, also hampered by the fact at this point the US isn't a party, so it would have to be a non-UNCLOS dispute resolution forum. Thank you.
Thank you so much time we have used. So about just 5 minutes later, so 15 minutes the next time. So about Mr. Carlos Carrera or Mr. Rajan, what do you have? Okay, then okay, you have Rajan. Okay.
Yeah, I don't know. Do I have about 2 minutes or so? Okay, I thought I would just leave you with a wild thought. It's basically, it refers to exploitation of mineral resources. We have a scenario here. We have got about 30 contractors working on areas beyond national jurisdictions, looking for mineral resources which they know might be there, or which they are sure of what they know. Apart from that, you have got several consortiums working on their external continental margin, looking for gas rates and oil and natural gas. Okay, so leaving apart that, the question was basically how much of an interest would coastal states have in exploring for mineral resources on their extended continental? Because see, the thing is that 30 contractors from about 14 countries working on areas much beyond their national jurisdictions. And then each of these countries also have their coastal areas, areas beyond continental. So the thing is that how do you balance? It's ultimately what I feel is that it's a question of balancing the cost economics. Sinking the money where you know where it is there already, or just sinking money in both ways. You are extended continental as well as areas beyond the national jurisdiction, and also putting the money where there's immediate return, oil and natural gas. So that is something which I thought I should highlight. In leaving apart all this environmental aspects and other things, to what extent would a coastal state have an interest in exploring for natural resources which they are not sure about having on their extended continental shelf? Look at even about less than 30% of the EEZ area has been explored for mineral resources, leaving apart oil and natural gas. So I thought I will just leave this, it's a kind of a wild thinking. I thought I will just spread the word around so that we can all think about it. What is going to be the outcome 5 years or 10 years down the line? That's it. Thank you very much.
Okay. Dr. Carlos Carrera, just to say hello, how are you? Anything you thinks you have a talk?
Well, we need to, very simply, we need to reflect on the fact that before there's any investment, there needs to be certainty. Dr. Rajan is correct. If there is no certainty about the boundary between areas under national jurisdiction and the area, it is very unlikely that the authority will venture getting close to that line, or that the state itself will try to exercise the exploitation of those natural resources in those areas. And those are 15 to 20 years ahead of us. There is time to do things right and to pay attention to all of the issues that Dr. Goulet, Professor Goulet, and Dr. Rajan raised during their presentations. The key aspect here is simply not oppose the research that is taking place, even under the auspices of the International Civil Authority, to explore those issues in order to move ahead with certainty. Thank you very much.
Okay, thank you. So we have a good finishing now. So we're going to have finish this sort of the afternoon sessions. So we thank you all. Have a good time. Good for the next homepage or the organizer and the organizing committee and their members are speaking on this issue. Okay, bye-bye. Have a good
Thank you very much.
afternoon,
Thank you.
and good see you. Okay, okay, bye-bye. Bye.
Bye-bye. Thank you. Thanks,
Bye-bye,
everybody.
bye-bye.
Thank you. Thank you. Thank you.
Okay. Okay, good.
Thank you.
Thank you.
Okay, thank you. We will now have coffee break. Please join us again 10 past 4. 4시 10분까지 다시 들어와 주시기 바랍니다.
이거는 나는 그냥 요거 음소거 해놔도 괜찮나? 괜찮나? 말할 때는 이걸 쓰고.
예, 맞아요.
그러면 막 올리.
Thank you. Now we start the second session. Dr. Kim Sung-jin, the former Minister of Oceans and Fisheries, will moderate this session. Now I will turn the session over to him.
Thank you. Good afternoon, everybody. I am Sung-jin Kim, former Minister of Ocean and Fisheries in Korea. I served as a minister from 2006 to 2007. After that, I served as one of the founder of this Global Ocean Regime Conference, together with Professor Yong-an Park. So I personally, I have deep concerns on this conference. Now we are entering the final session, session 2. The title of session 2 is Recent Development in the EEG and Fisheries Issues. We invited 3 speakers and also we invited 3 panelists. So in order to more effective conference, I suggest first 3 speakers are going to present, and after that, I would like to ask 3 panelists to comment or raise questions on the presentation from 3 speakers. We invited 3 speakers. First, Professor Hyun-soo Kim, Ina University, and secondly, Professor Entobas from University of Southampton. And thirdly, also we invited Professor Morena from Whitfield University. So now let me introduce Professor Kim from Ina University.
Thank you, Chair. Good afternoon, everyone. My name is Kim. I'm working at Ina University. Can I say this right? Yes. Okay, as you can see, the title to be presented today is Fisheries and Maritime Delimitation. So, and also, see, this is my presentation order. The presentation is divided in 4 parts: outline, relevant cases, issues to be examined, and finally I will conclude my presentation.
So far, currently, we have so many international maritime boundary disputes in the surrounding area of the world. So 434 cases are pending. Not pending, just is altogether of 434. And so just 168 cases were settled by the international judgment or by the agreement. Now, still 61% unagreed yet. So it's going to be a big conflict or dispute in our society. So to make an agreement on the maritime boundaries, we need to consider so many factors as relevant circumstances on maritime boundaries. So there, as you can see, there are so many factors, but particularly fisheries is one of the relevant circumstances to be considered in maritime boundaries. Fisheries is one of the non-geographic factors. So why is it the relevant circumstances are to be important to consider the maritime boundaries? Because it plays a role as to ascertain whether the final delimitation is equitable or not. You see, if some final line is not equitable, we need to consider so-called relevant circumstances, including fishing issues. But still problems. What is equitable solution? What is inequitable? It's quite ambiguous, so quite subjective. So there's a big hurdle to be overcome by all the concerned countries. So let me focus on the fishing effects of relevant circumstances on maritime boundaries. Relevance is a matter on how to consider final delimitation line if the final line is inequitable. In this regard, fisheries can be certain circumstances to be considered to produce equitable result, equitable solution. And so in this case, fisheries can play a role to create some equitable solution in maritime boundary delimitation agreement. Next, weight. Weight is a matter on degree, extent, what size of fishing. And also critical one is what extent fisheries may affect the final maritime delimitation process. So how can we weight the fishing issues in the maritime boundary delimitation negotiations? We need to find out exact weight of fishing issues on maritime boundaries. So let me try to focus on relevant cases on maritime boundaries. I would like to introduce 4 cases. Of course, we have so many international cases regarding maritime boundaries, but I will just introduce 4 cases. One, the case concerning maritime area delimitation between Canada and France. This is an arbitration case. Second one is the 1993 maritime delimitation case in the area between Greenland and Myanmar and Denmark and Bosses by ICJ. Third one is the 1984 maritime boundary delimitation case in the Gulf of Maine between Canada and USA by ICJ. Final one is the Iceland-Norway case by the Conciliation Commission in 1981. I will just slightly touch upon each case. One, the case between Canada and France in the Atlantic Ocean. Of course, Canada and France are so keen to catch a fish in that area, so they claimed fishing has to be considered. So arbitration award also accepted both countries' argument and claim. So particularly arbitration award decided that the geographical factor, and particularly fishing, is to be a core issue on maritime boundaries. So award suggests that the maritime boundaries should not take on a radical effect on the fishing, on the type of fishing. Of course, fishing is quite important, core issue to be considered. But the maritime boundaries should not take a radical effect on the type of fishing. As luckily, arbitration awards accepted both countries' traditional fishing rights. So anyhow, fishing could play a role in maritime boundary delimitation between two nations in the Atlantic Ocean. Next case is between Denmark and Norway, the maritime boundary delimitation. Can you see the maps? So look at that. As you see, Greenland is quite big one. As here is some Jan Mayen is a small island of Norway. It's, of course, both nations are heavily dependent on fishing issues, particularly capelin. Capelin is one of the major fish stock in the Arctic Ocean. Particularly, Greenlands are heavily dependent on fish stock, capelin. So ICJ also accepted both nations' claim on the fishing, particularly capelin. So the court drew the middle line. Take a look at please. Middle line is this one is solid one, and between the Greenland and the Jan Mayen. But the Greenland is big, quite big one, and Norway, Jan Mayen is small island. So and also Greenland is much more dependent on fishing resources in the Arctic Ocean. So boundary line should be shifted, adjust to the Norwegian side, Jan Mayen side. And so final delimitation here is a dotted line. So slightly move to the Norwegian side. Next case between Canada and USA in the Gulf of Maine. So it was settled by the ICJ. Particularly USA stressed that the conservation management of the fish stock, and also Canada also concentrates two aspects. First one, the distribution of the fish stock and the fishing practice of the parties. Anyway, two countries are so keen to catch a fish in the George Bank. The George Bank is ample ground for fishing by both nations, particularly USA and Canada. So, but unfortunately, ICJ chamber did not accept both nations' fishing dependence or fishing importance. So, why? Because according to the ICJ chamber, the limitation should not entail catastrophic repercussion for the livelihood. Yes, of course, we can consider fishing issues, but the final line, I mean, because of fishing issues, the delimitation should not entail any catastrophic repercussion for the livelihood. So ICJ chamber did not regard fishing issue as an relevant circumstance in this George Bank area. Finally, the Iceland-Norway maritime boundary case between and Iceland-Norway in the also Arctic Ocean in 1981. This was decided by the Conciliation Commission, and so Iceland is quite big one. Then Norway Jan Mayen, so imagine almost 300 times bigger than Jan Mayen and Norway. So Conciliation Commission accepted Iceland's heavily dependent on fishing issues than Jan Mayen Norway. So please take a look at this. This is a dotted line, is a median line between two nations, and then but final delimitation was shifted to the Jan Mayen side. This one. So this was decided by the Conciliation Commission. So I introduced 4 cases: ICJ arbitration case, and also ICJ chamber, and also Conciliation Commission. Next, move on to the surrounding area of the Korean Peninsula, Korea, China, Korea, Japan. Both nations, I mean, 3 nations already made an agreement on the fishing. Why? Because they could not make an agreement on the EEZ. So they just provisionally made an agreement on just fishing. So fishing was settled between the concerned state, Korea, Japan, and Korea, China. And also, please take a look at the Southeast and Northeast countries. And red colored area just a future negotiating area for the EEZ boundary. Still, those countries could not make an agreement on the EEZ boundaries yet. So it's going to be another big trouble between the Northeast and South Asian countries. But luckily, Vietnam and China in the Gulf of Tonkin, they made a bilateral agreement. So lucky case. But I think this it was done in 2000. So the two nations made agreement on the fishing issues and also EEZ boundaries. So quite good model. And also Japan and Taiwan and also made an agreement on fishing, just fishing. That's not EEZ boundaries in the surrounding area of the Diaodao or Senkaku area. So maybe in the near future, they need to make an agreement on the EEZ boundary as well. But you know, still there's some territorial dispute on the Senkaku and Diaodao. So it's in a big trouble. So they are just hesitating to make an agreement on the EEZ boundary. In summary, the weight of fisheries in maritime boundary delimitation, the weight of fisheries mainly depend on the following element. So when we consider maritime boundaries, we need to focus on the following elements: the degree of dependence on fisheries, location of distribution of fishery resources, traditional or historic fishing rights, and also finally classification of maritime delimitation. These are four major elements to be considered in the maritime boundary to decide weight of fishing. Next, I would like to focus on the issues to be examined. I would like to suggest two issues to be examined. How to determine the relevance of weight of fisheries on maritime boundaries. Of course, we need to consider relevant cases and state practice to produce the determination of the relevance of fishing on maritime boundaries. And next one is how to find whether fishing issues may take an effect on maritime boundaries or not. So we need to find out two big issues: how to determine the relevance of fishing issues, particularly weights of the fisheries, and also how to find whether fishing issues may take an effect on maritime boundaries. Why? Because UNCLOS, just as UNCLOS is one of the multilateral treaties, so UNCLOS did not provide any detailed contents or criteria for the circumstances to be considered in the maritime boundaries. So a diverse interpretation or application may be possible, may be anticipated. That's the biggest hurdle we have. Each nation has each different legal view, legal interpretation on each provision, each articles. So it's going to be quite difficult questions. Maritime delimitation, as you know well, is a very complex and multiform subject. Just UNCLOS just set forth only the goal to achieve equitable solution. That's it. To achieve equitable solution. That's a provision by the UNCLOS. And UNCLOS say nothing about how relevant circumstances to be considered. There's no reference on that. It is totally dependent on the interpretation of the concerned state or interjudicial body's decision or judgment. That's why many concerned countries try to resort the case to the court because they cannot easily make an agreement between the concerned countries. Why? Because UNCLOS did not say anything about the relevant circumstances in details. And so I surveyed some international cases and bilateral agreements. Just here, 7 international cases. So 4 cases fishing is took an effect on the maritime boundaries. 3 cases are not. And also, I surveyed 8 boundary and bilateral agreements. So most of the bilateral agreements took fishing issues as relevant circumstances in maritime boundaries. Particularly some neighboring countries are so keen to catch a fish because most of the fishermen are heavily dependent on the each nation, the fishing itself. So fishing issues may take a great impact on the maritime boundary limitation as relevant circumstances. So I will conclude my presentation here. So maritime boundary must be fair and equitable, yes, and take into account relevant circumstances, including fishing issues. And also, but still we have some big questions. So I would like to suggest carefully 2 questions or maybe 2 suggestions. How to determine the relevance of fisheries in maritime boundaries? Of course, we need to consider method of approach, criteria, element, evidence, so many things to determine the relevance of fisheries in maritime boundaries. And next, how to determine the weight of fisheries in maritime boundaries limitation in terms of the international jurisprudence or safe practice. So when we negotiate for the maritime boundary limitation, we need to consider every element. Of course, fishing will be one of the major relevant circumstances to be considered in the maritime boundaries. Why? To produce equitable solution. This is the final goal for the maritime boundaries between the concerned countries. In terms of the UN Convention, the final goal is to achieve equitable solution. To achieve equitable solution, we need to consider the fishing issues as a relevant circumstance in maritime boundaries. Thank you so much.
Thank you very much, Professor Kim. Especially, I thank you for your keeping on-time presentation. Professor Kim introduced the relevant cases on the maritime boundary delimitations, and also he suggested we need to consider special circumstance to adjust the provisional equidistance in fishing zones. And finally, he raised 2 important issues regarding maritime boundary delimitations. Now, I would like to invite Professor Antobas. Are you ready?
Thank you, Mr.
Yes.
Moderator, Minister Sun Jin, distinguished delegates, ladies and gentlemen, good afternoon to all. I'm delighted to participate in this conference, and it is my privilege and great pleasure to join the esteemed colleagues at the panel on fisheries and the expert discussions. I would like to thank for these honors in particular the organizers, the Korean Maritime Institute and the Ministry of Oceans and Fisheries. This afternoon, I would like to take the opportunity to attempt a retrospective, as you can see in my title, on issues as well as prospects relevant to the exclusive economic zone and the compatibility rule for the conservation and management of highly migratory species within the context of the Western and Central Pacific Fisheries Commission. The reason why I have chosen to do so is because exactly 20 years ago to this month, the Convention on the Conservation of Highly Migratory Fish Stocks in the Western and Central Pacific Ocean was adopted in Honolulu. Before I firmly fix my focus on the West Central Pacific, I would like to discuss briefly, first by means of a short background information on the concept of compatible conservation and management measures. This rule was established in the 1995 United Nations Agreement for the implementation of the provisions of the United Nations Convention on the Law of the Sea relating to the conservation and management of highly migratory stocks and strategically fish stocks. For convenience, I will refer to that as the Fish Stocks Agreement. This rule, in short, stipulates that conservation and management measures taken by coastal states within the exclusive economic zone and those taken by fishing states on the adjacent high seas and further on to the high seas should be compatible. However, this rule has been regarded as representing one of the most controversial elements. For some, the ambiguity lies in the legal uncertainty about the measures which should be regarded as the primary referential basis of the conservation and management scheme. In other words, the question of which measures must be compatible with what measures. Shall a coastal state adjust its measures to those taken on the high seas, or shall fishing states succumb to syndromes of coastal creeping jurisdiction onto the high seas? As in the past, within the context of the 1982 Law of the Sea Convention, for example, the swordfish stocks case between the European Commission and Chile, the issue of compatible measures due to the above substantive ambiguity is expected to give rise to disputes regarding the conservation and management of fish stocks also within the agreement. Even though the agreement provides for the settlement of disputes by incorporating mutatis mutandis, as we call it, the scheme of the convention, its effectiveness in terms of compulsory procedures entailing binding decisions has been largely questioned in relation to this specific kind of disputes. This is mainly because of a limitation on the applicability of the dispute settlement procedures available to be invoked by coastal states with regards to their sovereign rights within the exclusive economic zone. In addition, also other parallel jurisdictional issues which have been adjudged in the context of the 1982 convention, for example, the southern bluefin tuna, and the NAFO dispute between Spain and Canada, before the entry into force of the Fish Stocks Agreement, nevertheless, may reflect a discouraging precedent for compulsory adjudication. The concern over the applicability of the 1982 Convention compulsory procedures on compatibility disputes under the Fish Stocks Agreement has been at length debated in this respect, and various opinions have been expressed in rather cautious terms. Indeed, the legal nature of compatibility disputes raises several questions regarding the conservation and management of such stocks across jurisdictional areas, which, if not being addressed through compulsory settlement procedures, may frustrate the ecosystem approach, which constitutes the fundamental objective of the agreement towards the implementation of the convention. To this end, the availability of such procedures able to cover the full geographical scope of compatibility disputes is essential. Now, following this brief introduction, allow me to start making my way closer to the main aspects of my retrospective with regards to the Honolulu Convention, which is the treaty-based and constitutive instrument of the Western and Central Pacific Fisheries Commission. A convenient connection to do so is by recalling and paying a tribute to a key figure for both the Fish Stocks Agreement and the Honolulu Convention. The late but long to be remembered Ambassador Satya Nadna, who passed away unfortunately earlier this year on February 25th, was an international leading figure in ocean affairs. He is mostly associated with the International Seabed Authority as its first Secretary General, but here today I would like to remind us of his exceptional services also to fisheries, and in particular for the development of the Western and Central Pacific Fisheries Commission. The late Ambassador Nandan, a person drawing his experience and skills from the negotiations in the third United Nations Conference for the Law of the Sea, was the chairman of the Fish Stocks Conference, and in that capacity, he personally managed the negotiations and the development of the text of the 1995 agreement. He also played an important role as the father of the Western and Central Pacific Fisheries Commission Conference by guiding also those negotiations and drafting as well the text of the Honolulu Convention, and finally serving the Commission itself as one of its chairmen. Now, back to the rule of compatibility and regarding highly migratory species, this rule has been applied in the region of the Western and Central Pacific Ocean by the Honolulu Convention. And I hope that you will be able to see my second slide regarding the convention area. Acknowledging in the preamble that compatible, effective, and binding conservation and management measures can be achieved only through cooperation between coastal states and states fishing in the region, and setting out among the objectives, notably the objective of ensuring through effective management, the long-term conservation and sustainable use of such stocks. In this respect, conservation and management measures are applicable throughout the range of the stocks within the conventional area. In particular, it is explicitly stated that the conservation and management principles and measures endorsed by the convention shall be applied by coastal state within areas under national jurisdiction in the convention area in the exercise of their sovereign rights. Explicating the compatibility rule, the convention stipulates further that conservation and management measures established for the high seas and those adopted for areas under national jurisdiction shall be compatible in order to ensure conservation and management of highly migratory fish stocks in their entirety. The balance of interest between coastal and high sea states is further amplified through the provisions which require the Commission that in establishing compatible conservation and management measures for highly migratory fish stocks, it shall take into account both measures that are adopted and applied within areas under national jurisdiction and measures established and applied in respect of the same stock on the high seas. In addition, the convention expressly establishes a corresponding obligation for the coastal state in stating that they shall ensure that the measures adopted and applied within areas under their national jurisdiction do not undermine the effectiveness of measures adopted by the Commission in respect of those stocks. It has created, therefore, an explicit duty for coastal state to apply measures within the exclusive economic zones compatible with those adopted by the Commission. Now, moving on, please allow me to consider next the nature of a likely type of a compatibility dispute, possibly a bit more complex. The Honolulu Convention adopts a remarkably broad and possibly open-ended description of activities regarding what constitutes fishing, not so only to actually catching, taking, harvesting of fish, but even for attempting at search for this. Moreover, taking into account the principles and measures for conservation and management, it provides that in order to conserve and manage highly migratory fish stocks in their entirety, the members of the Commission, in giving effect to their duty to cooperate in accordance with the 1982 Convention, the 1995 Agreement, and the Honolulu Convention, shall assess the impact of fishing, among other activities, as well fishing on non-target species, both fish and non-fish species, and species belonging to the same ecosystem or dependent upon or associated with the target stocks. This kind of biological associations and dependencies could possibly give rise to a compatibility dispute, and, for example, circumstances that could have a potential bearing to such eventuality can be seen in the recent developments in relation to illegal, unreported, and unregulated fishing activities, not targeting a highly migratory species directly, but rather another type of a fish stock that is associated or dependent within the geese of the ecosystem approach. To be more specific, an interrelationship of that kind pointing to a situation of an adverse biological impact on non-targeted components of the ecosystem may be the one between swordfish and squid. On the one hand, swordfish is a species that occurs within the conventional area and is included in the stock assessment schedule of the Commission. And for some members, it reflects one of the key priorities. There have been also some discussion last month in August at the 16th regular session on the Scientific Committee under topic 14 regarding the management of swordfish as bycatch in longline fisheries, in the context of which a number of options have been put forward, including, among others, the removal of squid bait from non-target fisheries that can be tested under the umbrella of the assessment. On the other hand, there is a food chain dependency of swordfish and other highly migratory species such as big eye and yellowfin tuna upon squid stocks, and various types and families of squid, such as the Pacific flying squid, while previously being moderately fished, have now come themselves under fishing pressure in a number of regional straddling stocks. For example, it has been widely reported on the news, more recently during July and August, the alleged widespread activity of a certain distant water fishing state, which is also a member of the Commission for illegal, unreported and unregulated practices by ghost fleets targeting stocks of squid from waters under the jurisdiction of North Korea, as well as at the other side of the ocean, just off the Galapagos Islands. Having considered the likely type of compatibility dispute, let me next discuss the role of dispute settlement. As yet, we have not seen a compatibility dispute under the terms of the agreement to be referred to international adjudication. There have been a few review panel proceedings within the context of RFMOs and a limited, if not entirely incidental and inconclusive reference being made by the Chagos arbitration, which can only be seen, I believe, as a rather shaky obiter dictum in passing. So in short, we do not have a dispute that we can describe it as a textbook classical case. The dispute settlement procedures of the agreement have been incorporated by means of reference in the majority of RFMOs and arrangements that were established after its conclusion. This is also the case with the Western and Central Pacific Fisheries Commission. On the back of this point, it should be further noticed that the Western and Central Pacific Fisheries Commission was one of the two very first organizations that came to life after the conclusion of the Fish Stocks Agreement. The first one was the Convention on the Conservation and Management of Fishery Resources in the Southeast Atlantic Ocean, which was negotiated in 2001 and entered into force in April 2003. The Honolulu Convention succinctly yet effectively states that in any case where a dispute is not resolved through amicable means, which may include an ad hoc expert panel regarding technical disputes, the provisions relating to the settlement of disputes set out in the 1995 agreement shall apply to any dispute between the contracting parties. In the light of the above incorporation, it is therefore interesting to discuss how the principle of compulsory dispute settlement has been received among the parties of the Commission. Indicatively, the Japanese delegation, reviving a long-standing controversy with the Pacific Island Forum Fisheries Agency over the interpretation of UNCLOS Article 64, opposed the principle of compulsory settlement with regard to compatibility disputes throughout the negotiations of the Honolulu Convention. Notably, it recorded a declaration regarding the interpretation or application of the proposed dispute settlement procedure, which is worth mentioning. During the final stage of the multilateral high-level negotiations, Japan viewed that a dispute arising between two or more of the parties concerning the interpretation or application of the convention should be resolved diplomatically within the framework of the Commission, and if any dispute will not be resolved, it should be referred for settlement for compulsory procedures only with the consent of all parties to the dispute concerned. However, the Japanese declaration was not materialized in the final text of the convention. Contrary to Japan's views, was a statement made by Ambassador Nandan, who, as I briefly mentioned earlier, was responsible to draft and develop the text of the convention, whereby he viewed that the fundamental precept in the regime is that there is provision for compulsory and binding dispute settlements arising from disputes over the interpretation and application of the convention. These procedures are based on the widely accepted norms contained in the 1982 Convention, which is the paramount instrument governing all ocean-related activities. The wide acceptance of those procedures was also recognized by their inclusion in the Fish Stocks Agreement, and they are now incorporated in this convention. Hence, as far as the Western and Central Pacific Fisheries Commission is concerned, disputes involving highly migratory species remain fully within the ambit of compulsory procedures, enabling a court or tribunal to assert its compulsory jurisdiction in spite of their relation to the exercise of coastal state sovereign rights. Now, let me move on to my final point as to the significance of the Honolulu Convention today, considering the particular dynamics in the sub-region of the Korean Peninsula. And I would like to point you to the third slide that I have provided. There are two reasons which I would like to emphasize. First, in terms of treaty dynamics, the convention provides an important common nexus among China, Japan, and the Republic of Korea as members of the Western and Central Pacific Fisheries Commission as well. The importance of that common legal ground lies in the fact that China has only signed but not ratified the Fish Stocks Agreement. The Honolulu Convention, nevertheless, largely reflects and effectively incorporates substantially parts of the agreement in relation to substantive and procedural aspects of the compatibility rule, making these in turn also legally binding to China. Secondly, in terms of the bilateral arrangements which are in place regarding the delimitation of the maritime zones. And I would like now to point you to the final slide that I have provided. Of course, here the main issue is the still undefined on a permanent and a full basis maritime boundaries. And as a result of this, the need of resorting to several bilateral fisheries agreements in the immediate area. Namely, the agreement between China and Japan, the agreement between Korea and Japan, and the agreement between Korea and China. And I would like to stay a little bit more on the last one. The fisheries agreement between Korea and China features a provisional measure zone and the so-called white zone. But I would like also to provide an interesting detail as a footnote. In relation to the latter agreement, it will be interesting to take from the historical anecdotes the detail that both China and Korea acceded later to the Honolulu Convention. While both Korea and China were among the participants in the conference and the convention opened for signature on the 5th of September 2000, remaining open for 12 months, the two states acceded as per the modalities offered in the Honolulu Convention much later on. Korea did so on 26 October 2004 and shortly after China on the 2nd of November 2004. So they left considerable time as to allow the fishery agreement between them to enter into force, and that happened in 2001, whereas the agreement had been already adopted since the 3rd of August of 2000. The fragmented zonal landscape has become frequently the theater of disagreements between the parties as to allocated quotas, stock measures and fishing patterns, as well as on matters of enforcement regarding the presence of the number of fishing vessels by the parties, but most importantly with regards to illegal, unreported, unregulated practices by third states. These bilateral agreements, in lacking in addition a holistic view of the biological nature of the fish stocks in the conventional area, may bring in question the responsibility of the respective coastal state with regard to in-zone measures. Finally, I would like to conclude with a couple of prospects which I consider important for the future. First, while in relation to highly migratory species, the Commission provides, as I discussed, an innovative and comprehensive arrangement, attention should be now turned to straddling stocks. That will be important not only due to the presence of significant stocks that straddle the exclusive economic zones, but also from an ecosystem approach in the light of the stock's biological interaction, as for example, my comments on the ongoing concerns regarding squids illustrated. Whether directly over the states in the sub-region, provided that the ongoing matters of pending delimitations do not obstruct the aims of conservation and management, or by means of a future fisheries commission tasked to this aim, this is imperative as to avoid adverse impacts on the marine environment. Secondly, I think it's important to reiterate the need for North Korea to come out of the marginal position in which currently resides. To this end, the first step must be made from the side of North Korea by ratifying the Law of the Sea Convention, which it has already signed on the day that the convention opened for signature on the 12th of December 1982. The second step needs to be the continuing encouragement of North Korea by the Commission to become a cooperating non-member party, if not later on a full member by means of an invited accession, in order to assume responsibility for fishing activities, able to ensure the long-term conservation and sustainable use of straddling fish stocks and highly migratory fish stocks on its behalf, as well as with regard to third states which reportedly are fishing in an abusive manner within her own jurisdiction. In conclusion, I firmly believe that we are indeed living in an era that the so-called hydropolitics are shaping the global agenda. As natural resources have been always a fruitful ground for friction, it is imperative to avoid conflicts. And when it comes to the sustainable management of fish stocks, there must be a commitment to the international cooperation framework under the regional organizations and arrangements, but also a confident reliance when necessary on the procedures for the peaceful settlement of disputes. Thank you for kindly listening to my presentation.
Thank you very much, Professor Entobas. Professor Entobas explained WCPFC and he also explained the Honolulu Convention. Yes, he focused on the fisheries conservation and the management of fisheries resource, and he also introduced the consistency principles. Yeah. Also, he explained the dispute settlement procedure and some remaining or in other words, hidden possibility of dispute around the Korean Peninsula. And finally, he re-emphasized the importance of the sustainable management of fisheries resources. Thank you very much again. Now, I would like to invite our final speaker. Professor Molina, it's your floor.
Dear Minister, dear distinguished participants, it's an honor and a pleasure for me to participate in this very interesting conference. I'm very grateful for having been invited, in particular by Jung Kil, and I would have loved to be there with you in Busan, but this was of course not possible due to the extraordinary and historic events that we are now experiencing. I hope to be able to visit your beautiful city sometime in the future. Today, I will be giving a presentation on the origins and recent developments within the North Pacific Fisheries Commission. And this is what I would like to cover in my presentation today. So something more in general about regional fisheries management organizations and arrangements and their role in international fisheries law. And of course, the NPFC is an RFMO established by the NPFC Convention. Then some key features of the NPFC, its origins, and then recent developments. As I've been involved in the NPFC through the delegation of the EU, I want to emphasize that the views expressed during this presentation are my personal views and not necessarily those of the Netherlands government or the European Commission. RFMOs are at present regarded as the preeminent institutions of international fisheries law, and this is also recognized in the 1995 Fish Stocks Agreement and the 2009 Port State Measures Agreement. There is no generally accepted definition for RFMOs in the United Nations Convention on the Law of the Sea, UNCLOS, the Fish Stocks Agreement, or elsewhere. But in this presentation, I will treat them as regional intergovernmental mechanisms for the conservation and management of fisheries resources. RFMOs are a subset of the regional fisheries bodies used or distinguished by the UN Food and Agriculture Organization, and there are more than 50 of these. So this subset only deals with marine fisheries and not inland fisheries, and they have a mandate to impose legally binding conservation and management measures on their members. There is wide diversity among RFMOs today, and this is reflected in their key distinctions and types. So one of these is the type of institution. So some establish an intergovernmental organization, the RFMO. Others, such as the regional fisheries management arrangements, they have a conference or a meeting of the parties. Most RFMOs are standalone, but some are part or established under an overarching regime or institution, such as the FAO RFMOs, the General Fisheries Commission for the Mediterranean and the Indian Ocean Tuna Commission. As regards their geographical mandate, RFMOs can define their mandate to only coastal state maritime zones, the high seas, or both. And in terms of species, their mandate can comprise groups or specific target species or all residual target species in a geographical area. So for tuna species, there is one RFMO that focuses only on one tuna species, southern bluefin tuna, the CCSBT. At this stage, there are 16 RFMOs with a geographical mandate that includes high seas areas or that consist exclusively of high seas. And these are the 5 tuna RFMOs, including in the Pacific, the Western and Central Pacific Fisheries Commission and the Inter-American Tropical Tuna Commission. And this is supplemented by a layer of non-tuna RFMOs, so of which there are 11. So these deal with other species, residual species. And the most recent of these is the Central Arctic Ocean Fisheries Agreement, which creates a temporary and qualified abstention of high seas fishing in the high seas part of the Central Arctic Ocean. And both the EU and South Korea participated in its negotiation. There are 5 functional areas of RFMOs. So one relates to conservation and management. And this comprises, for instance, the establishment of total allowable catches, monitoring, control, and surveillance, comprises port state measures, observers, catch documentation scheme, compliance and enforcement, compliance assessment committees, vessel lists for illegal, unreported, and unregulated, so IAU fishing, governance, so decision-making, dispute settlement, but also capacity building and cooperation between RFMOs, and then finally the science. So it covers the quality and provision of scientific advice that is required for stock assessment. So something on the key features of the North Pacific Fisheries Commission. It's the newest RFMO. It was established in 2015 when the convention entered into force. It deals with high seas of the North Pacific Ocean, so not in the coastal state maritime zones. And it has a residual species mandate, and this is typical for all non-tuna RFMOs, as I explained. So in this case, so it doesn't deal with tuna or tuna-like species, and also not with salmon, which is governed by the North Pacific Anadromous Fisheries Commission. So NPFC distinguishes 8 priority species, and 2 of these are, for instance, Pacific Sauri and chop mackerel. At present, there are 8 members: China, Canada, Japan, Korea, Russia, US, Vanuatu, and Chinese Taipei. And there is only one cooperating non-contracting party, and that's Panama from 2019 onwards. And Panama is only interested in transshipment and bunkering activities. So as regards the origins of the NPFC, a distinction has to be made between the mid-2000s and the early 1950s. So as regards the mid-2000s, the origins are based on concerns on impacts of bottom fisheries on vulnerable marine ecosystems and target species, and subsequent action by the United Nations General Assembly, for instance, in 2004. And this is also reflected in the first meeting or session of the negotiations on the NPFC, which is entitled First Intergovernmental Meeting on Establishment of New Mechanism for Management of High Seas Bottom Trawling in the Northwestern Pacific Ocean. So during the 10 sessions over which the negotiations took place, the objective geographical area and participation gradually broadened. As is evident in the title of the first meeting, it had a relatively narrow focus on bottom fishing, but the title, which would be addressed by a mechanism. The title of the 10th meeting was Multilateral Meeting on Management of High Seas Fisheries in the North Pacific Ocean. So the focus is on residual species and not just bottom fishing, and it would be managed by an RFMO. As regards the geographical area and participation, this is reflected in the fact that the first 5 meetings only involved 4 delegations: Japan, South Korea, Russia, and US. From the 6th meeting in 2009 onwards, however, Canada also participated, presumably as a result of the desire to broaden the geographical scope of the convention area by also including the high seas adjacent to the EEZ of Canada. Chinese Taipei participated, from the 7th meeting in August 2009 onwards on account of the ongoing fishing activities by its vessels for relevant species. At the end of the 7th meeting, the delegations decided to invite China and Mexico, the latter presumably on account of its capacity as a possible coastal state, and the former presumably on account of its vessels' engagement in relevant high seas fishing. Of these two, only China accepted the invitation and participated from then onwards. So the negotiations were concluded in 2011, and then a preparatory conference took over, and this lasted until 2015, when the convention entered into force and the NPFC was established. The origins of the NPFC actually go further back to the early 1950s. In 1953, the International North Pacific Fisheries Commission was established, the INPFC, and it only had 3 members, Canada, Japan, and the United States, and there was no possibility for accession by additional states. Nevertheless, it engaged with non-members and their fishing, for instance, the USSR, Republic of Korea, and Poland, as well as various others, such as Mexico and states that are now members of the EU, Bulgaria, Germany, Greece, Portugal, and Spain. So these states all had historic fishing presence in that area. In terms of species, this commission had a mandate of all species, but they distinguish also 3 priority species: halibut, Pacific herring, and various salmon species. And for these species, there was a so-called abstention policy. In 1979, due to the emergence of 200 nautical mile exclusive economic zones, so EEZs and exclusive fishery zones, the mandate of the INPFC primarily was restricted to salmon. And as regards halibut, its mandate was transferred to the International Pacific Halibut Commission. Another step took place in 1991 when negotiations commenced on the Central Bering Sea Convention, which would regulate the fishery, the high seas fishery for pollock. Negotiations were also started on the North Pacific Anadromous Fish Commission, and the NPFC, which would have a mandate for salmon and consists basically of a prohibition. That same year, negotiations on the North Pacific Marine Science Organizations, or PICES, had concluded. The PICES was to be a successor of the scientific component of the Northeast Pacific panel of the INPFC, but would not have a regulatory mandate. In 1993, the INPFC was dissolved, but in fact, by that stage, the 4 bodies that I've just discussed had succeeded it, and there was only one gap in that regard, and that was the regulatory mandate of the Northeast Pacific panel, and that is now in fact the NPFC. Something on recent developments in the NPFC. It's a young RFMO, in fact the youngest, so significant efforts are needed to ensure good performance in all main functional areas of RFMOs, but in particular on the scientific basis for the management of the 8 priority spaces and the development of conservation and management measures, of which there at the moment are quite few. So far, there have been 5 annual meetings between 2015 and 2019. And the 6th meeting that was scheduled for 2020 had to be postponed to February 2021 due to the COVID-19 situation. The question is if it will be a virtual or a normal meeting. Many RFMOs at this moment are meeting only virtually. The scientific committee of the NPFC and various of its subsidiary bodies are scheduled to meet virtually in November 2020. So another recent development are the EU's attempts to obtain membership of the MPFC. The EU did not participate in the negotiations on the MPFC and also expressed no interest to do so at the time. There's nevertheless an implicit reference to the EU included in Article 24 of the Convention on Accession. And this provision makes reference to regional economic integration organizations. And it's generally accepted that the EU is the only intergovernmental organizations that qualifies as an REIO. So the EU did not ask for this provision, so the initiative for its inclusion must have come from one of the delegations, presumably on account of the general acceptance by the international community that the EU is a full participant in international fisheries law and the international law of the sea more in general. In 2017, EU operators fishing for small pelagics in the South Pacific in the convention area of Strefmo expressed an interest to fish for similar species in the North Pacific. And in 2018, the EU submitted a request for membership, and the MPFC refrained from deciding on it due to a lack of specific information and probably also time. In 2019, the EU made a second request for membership, and Russia blocked consensus in this regard. And I'll talk a little bit more about that later. In January of this year, the EU made a third request for membership. And of course, due to the postponement of the annual meeting, this has not been dealt with. It's good to emphasize that the EU was not the first entrant. Faroe Islands tried to become involved in the negotiations on the MPFC convention, but was unsuccessful. Vanuatu became involved in the MPFC during the preparatory phase and was eventually invited to accede to the convention and became therefore a member. There's a dilemma faced by the EU, and this is quite similar to other new entrants to other RFMOs. So as a non-member, if you're not a cooperating non-contracting party, any fishing by your vessels is treated as IUU fishing, and vessels are generally listed on IUU vessel lists, and then action is taken against those vessels. If you are a member or you have obtained CNCP status, this does not automatically bring you an allocation of fishing opportunities or quota. This has to be negotiated. Also, non-members to the MPFC do not have a right to accede, but can only request to be invited to accede. This is the so-called approval role of the MPFC. This is reflected in Article 24 of the Convention, and it says there that the contracting parties may, by consensus, invite to accede to this convention. So in this case at issue, the various rights and obligations under the UNCLOS and the Fish Stocks Agreement that are relevant, such as the right to fish in the high seas, the right of states with a real interest to become member of RFMO, and a prohibition to discriminate in that regard. This is laid down in the Fish Stocks Agreement. A right to engage in fisheries-related activities, such as transshipment and bunkering, and various obligations to cooperate in relation to transboundary fish stocks and discrete high seas fish stocks. And these are, of course, a two-way obligation, not just for the applicant, but also for the members of RFMOs. There have not been any cases on participation in RFMOs before international courts or tribunals so far. And this is due for various reasons, including that dispute settlement mechanisms are insufficiently tailored to the scenario at hand. As a non-member of an RFMO, it's obvious that you do not have access to the dispute settlement procedures of that RFMO. The procedures laid down in the UNCLOS and the fish stocks agreement would be available, but only in relation to members or contracting parties to those instruments. And also cases cannot be brought against RFMOs, but would have to be brought against all members in parallel. And this will be a logistic and a very time-consuming and costly affair, and that's very obvious. The NPFC convention is unique for various reasons, but also that it has a constraint on this invitation by consensus rule that we've just discussed, and this constraint is laid down in Article 24, paragraph 3. So it specifies that any contracting party that does not join the consensus in relation to paragraph 2 shall present to the Commission in writing its reasons for not doing so. So the reason for this is that recent decisions in written form presented to the other members of a commission will help to avoid abuse of rights. So in fact, Russia's reasons have been included in Annex E to the 2019 report. And this is quite interesting because this is not strictly required by Article 24, paragraph 3 of the convention, which only requires internal transparency. Providing these reasons also to the applicant, so in the EU in this regard would have been an additional step, but the NPFC has in fact decided for full transparency and made these reasons available to the broader public by including them in a report. So I guess this means that the EU, if it were to bring a case, would not have to bring it against all members of the NPFC, but could only bring it against Russia. At this stage, however, there are absolutely no indications that the EU intends to do so, even though the EU statement in the 2019 report contains the wording, "We will consider all possible options in this regard." That's all. Thank you so much, and I look forward to the questions that may be raised later.
Thank you, Professor Moray. And Professor Morena presented the origin and the recent development based on his personal participation and experience. I think it's very precise and valuable presentation. And one of the unique features in the NFSC, he introduced the consensus rule for inviting new members. Anyway, once more, thank you so much. Now, I would like to invite 3 panelists. First, I would like to invite Professor Chano Park. Professor Park, take your applause.
Thank you, Mr. Chair. I am pleased to participate in this seminar as a discussant. I would like to make some comment on Professor Kim's presentation, Fisheries and Maritime Delimitation. As we all know, the United Nations Convention on the Law of the Sea provides that the delimitation of the EEZ is to be effected by agreement on the basis of international law in order to achieve an equitable solution. But it does not provide a specific method, but the general principles to delimit the boundaries. If a state cannot reach to the agreement, there is no choice but to go to judicial bodies to settle the delimitation problem. In this context, Professor Kim's presentation about the judicial decisions rendered by international courts is very helpful and useful to understand the trend in maritime delimitation. His presentation about the effect of fisheries to the delimitation is well analyzed. Let me talk about maritime delimitation in the Northeast Asian region, especially between Korea and China. As you know, there is no maritime boundary in the Yellow Sea between Korea and China. They have different positions on the delimitation principles. It is reported that China has argued equitable principles to be applied to delimit the Yellow Sea. As far as I'm concerned, China has emphasized the fisheries factor to be taken into account in the delimitation. But Korea is known to favor equidistance principle. The difference of positions between Korea and China is hard to be narrowed down. That's why the negotiation of delimitation between two countries has been processed more than 20 years. Although the output of the fishery industry accounts for less than 1% of the country's GDP in 2000, fisheries are very important to two countries, Korea and China. According to the FAO, China consumed 36% of the 153 million tons of total food fishery consumption in 2017. On the other hand, Korea ranks top per capita food fish consumption, 58.4 kilograms in 2015. But we have to face gloomy outlook. According to some studies, the major commercial fisheries resources in the Yellow Sea are at extremely low levels compared to a couple of decades ago. There is great environmental degradation of fishing habitat due to coastal development and maritime traffic. As a result, marine living resources in the Yellow Sea decreased significantly. That seems to be one of the reasons for China to pay attention to fishery resources in the maritime delimitation. Let me stop here and ask some questions to Professor Kim. According to my information, you have participated in the delimitation conference as a member of Korean delegation. Could you tell us the exact position of China about the fisheries as a relevant circumstances? Secondly, what do you think the practical solution is in the Yellow Sea delimitation? Lastly, is there any possibility for two countries to go to judicial bodies to settle delimitation problem? Thank you for your attention. Thank you.
Thank you, Professor Park. He presented very valuable comments together with 3 questions. The question will be answered by Professor Kim afterward. Okay. Now I would like to second panelist. Professor Shim. Yeah.
Thank you, Minister Kim. It is my great honor and privilege to be part of this meaningful program and to play a discussant's role in this wonderful session. I like to make some comments on Professor Molinar's presentation on North Pacific Fisheries Commission. And he actually gave us a wonderful overview of the origins and developments of this one of the newest RFMOs. So I don't think I could add much more to what he has already contributed. Instead, I'd like to make some general comments on the RFMO's status that would be discussed in the context of the ongoing the negotiations on the conservation and sustainable use of marine biodiversity of areas beyond national jurisdiction, which we often short as BBNJ. I'm also speaking from my experience as part of Korean delegation to the third intergovernmental conference on that of BBNJ issues, which was held last year. Well, basically, this BBNJ agreement intends to set the rules for 4 different areas. One is the regulation on the marine genetic resources, mostly related to the beneficiary access to marine genetic resources and the beneficiary that comes out of it. And also the area-based management tools, including the marine protected areas and the environmental impact assessments, and also the capacity building and transfer of marine technology for developing countries. And as I already said, this area-based management tools is one of these the hardest debated areas that is going to be included in the BBNJ agreement if it really comes about. And in this area, the role of the RFMOs are greatly emphasized in many different, from different angles. Well, it is true that the state parties to this incoming, the convention or the agreement will have freedom to establish area-based management tools, including marine protected areas. But they are also required to work with the many different RFMOs to establish these the ABMT measures. And if in case there is no such RFMOs in the specific regions, they would be allowed to set up their own the ABMTs, area-based management tools, on their own initiatives. But then an alternative to this topic was also suggested as if there is quoting, if there is no RFMOs in this specific region, they would seek to establish an RFMO first to allow themselves for setting up rules on the area-based management tools. So in many different perspectives, RFMOs were given the priority to set up the rules when it relates to the conservation and sustainable use of ocean fish and marine biodiversity. And this rule may be somewhat changed depending on the pace of the negotiations in the UN, but I am pretty confident that most most states participating in these negotiations have the positive view of the role that the RFMOs will play in the conservation and sustainable use of the ocean fish and the ecosystem. So I'm quite hopeful that even in after the conclusion of the international negotiation on BBNJ, RFMOs will be given more active role to play towards providing more protection for marine biodiversity and marine ecosystem. I'd like to make one short comment to the accession clause that Minister Kim had already mentioned, which I think is problematic from an institutional point of view. This Article 24 of this NPFC convention basically gives each member state a veto power to block a newly entrant to this convention. And I don't think this is quite helpful in strengthening the regulatory power of this one of the newest RFMOs in this North Pacific region. So probably the states may need to reconvene and then start discussing, revisiting this clause or revising it so as to strengthen the regulatory power of this the NPFC. And if time allows, I would like to hear more about Russia's reason not to join the consensus in the case of the EU's request for membership from Professor Molina. Thank you very much for your attention.
Thank you very much, Professor Sim. Professor Sim, focusing on the BNJ negotiation and the role of RFMO and the cooperative procedure in the future. Yeah, okay. And he also raised two questions. First, the Article 24 of MPFC Convention and the action by Russia. Now I would like to introduce the final panelist, Ki-bum Lee of Asan Institute.
Thank you very much, Chairman. It is my great honor to participate in this great conference. I would like to ask some questions for Professor Antovas, and I would like to make just a little bit comment regarding Professor Hyun-Soo Kim's presentation. Firstly, my questions go to Professor Antovas. Actually, I have read Honolulu Convention regarding Western and Central Pacific Oceans fisheries stocks. Yes, Article 8 is very important regarding compatibility of conservation management measures. I have three questions. The first one is paragraph 1 mentions areas under national jurisdiction. I recall some scholars argue 7 or 8 years, areas under national jurisdiction mean just the exclusive economic zone, excluding territorial sea, internal waters, or archipelagic waters. So could you provide your own perspective about areas under national jurisdiction? My second question is regarding paragraph 2, Article 8 of the Honolulu Convention. According to paragraph 2, the Commission shall take into account several factors, for example, biological unity and previously agreed measures and respective dependence of the coastal states and blah, blah. So yes, the Commission shall take into account several factors, but in the context, what should coastal states take into account to keep compatibility of conservation and management measures taken by themselves. My last question is regarding paragraph 3 of Article 8. The coastal state shall ensure that the measures adopted and applied by it to highly migratory fish stocks within areas under its national jurisdiction do not undermine the effectiveness of measures adopted by the Commission, blah, blah. So this paragraph uses the verb undermine. So I have found some tension between the possibility to undermine the measures taken by the Commission and keeping compatibility. So I found some substantial discretion of the coastal states. So that means if we have a focus on undermine, probably we could have found some discretion, substantial or considerable discretion of the coastal states. That means some risk of keeping compatibility. So could you provide some your own perspectives? And I would like to make some comments on Professor Kim's presentation. Actually, you have very well summarized the fishery issues regarding maritime boundary delimitation. Fishery issues, yeah, meaningful, relevant circumstances, different from bilateral agreements. International courts and tribunals have not taken into account fishery issues because they are not neutral circumstances. That means circumstances common to both exclusive economic zone or fishery zones and the continental shelf. The first case to actually only one case, 1993 Yanmain case, considered fisheries issues because the court had not created single maritime boundaries. Only the court had drawn two separate but coincidence lines without providing any specific reasons because of the jurisdiction issues. Yeah, as you mentioned, the 1984 Gulf of Maine case provided one criterion to consider fishery issues that was catastrophic repercussions. However, according to the arbitration tribunal in the 2006 Trinidad and Tobago and Barbados case, according to the arbitral tribunal, injury doesn't equate with catastrophe. So the criterion about catastrophic repercussion cannot be applied easily in international courts and tribunals, especially except for the 1993 Yanmain case. I think all of the cases international courts and tribunals in all of the cases have established a single maritime boundary to consider just the neutral circumstances. But however, fishery issues are not neutral circumstances. That's my just a little bit comment. Thank you very much.
Thank you, Dr. Lee. Dr. Lee raised three questions to Professor Antovas, and he also provided comments on Professor Kim's presentation. Yeah. Now, let me invite Professor Kim. And
Thank you, Mr. Chair. I would like to answer for the question. Two minutes, Professor Park raised three questions to me. One is what is the position of China about fisheries as a relevant circumstance? Yes, China strongly argued that fishing issues should be considered seriously in the maritime boundary in the Yellow Sea because China's fishermen are heavily dependent on fishing issues. That's why the radical region. So China is so sticking to the fishing issues in the Yellow Sea. There's another big hurdle to make an agreement on the EEZ boundary in the Yellow Sea. And even if EEZ boundary agrees in the Yellow Sea, China may require another fishing zone in the some part of the EEZ. It's not reasonable. And in there, China wants to fish alone or jointly fish with South Korean fishermen. So-called joint fishing zone or exclusive fishing zone may be required to be established in a certain part of the EEZ, especially in the close area to the Korean Peninsula. So ridiculous approach. But still, China strongly argue some kind of fishing zone has to be done in the area of some parts, maybe close to the South Korean Peninsula. We cannot accept it. So still, the Chinese attitude is not changed yet. But EEZ boundary is not a method to establish fishing zone in the EEZ. And so when both nations negotiate EEZ boundary, Korea maybe consider China's special position on fishing in the Yellow Sea. And second question is, how is the practical solution on the delimitation in the Yellow Sea? Yes, let me find out. If we find out some practical solution, that's a good answer. Of course, two nations have to try to solve the boundary delimitation in the Yellow Sea in terms of international rule of law, particularly UN Convention, safe practice, international judgment, or decision, or award. So many things we can consider. Both nations already ratified the UN Convention, so they need to make an effort to set the boundary delimitation within the framework of the UN Convention. So unilateral claims, particularly China, on the boundary are not allowed it in terms of the UN Convention. So why? Because UN Convention, the main focus, main goal is to achieve equitable solution. So unilateral claim is not based on the equitable solution. So I think the easiest way to resolve EEZ boundary in the Yellow Sea is to be based on the boundary negotiation agreement between the two summits within a certain time limit. That will be the practical solution on the EEZ boundary. It was agreement between maybe the two presidents or two summits. So, it will be a long procedure. And final question by the Professor Park is, what is the possibility of judicial settlement to solve the boundary between both nations? Yes, it's a possibility, but if it is not possible to settle the boundary within a reasonable time, maybe China, Korea may resort the boundary issues to the court, be ICJ or ITROS, under the agreement of both nations. But there's no possibility because China does not want to solve the dispute by the court, namely international bodies. Why? Because China prefer bilateral negotiation or agreement between the concerned state. That is China's national policy on the issue of maritime dispute. China strongly prefer just negotiation between the concerned state instead of resorting to the international bodies. And also, it is necessary to negotiate first. Yes, negotiation first, and then need to try to consider each nation's specific or special circumstances in consideration of international law, state practice, and international judgment, decision or award. So that's my answer raised by the Professor Park's question. Okay, and also Dr. Lee made a comment on my presentation. I like briefly add on that. Yes, through the international cases, we can see the fishing issue took an effect on the maritime boundaries. But it's not a sufficient cases. Just a few cases took an effect on the fishing issues in the maritime boundary. But when we look at the bilateral agreement, most bilateral agreement took an effect on the fishing issues mainly in the maritime boundaries. So it depending on the situations, but each nation has different situations, particularly geographic or non-geographic situations. So we need to find out, and we need to carefully consider what is the relevance of fishing issues, or what is the weight of fishing issues in the relevant areas. Thank you.
Thank you, Professor Kim. Your brief and precise answer. Now, I'd like to invite Professor Morena. Professor Morena, please provide your views on 3 questions by Professor Sim.
Yes, thank you so much. And thank you, Professor Shim, for your very interesting questions. I think there are 2 main questions. One on the invitation by consensus rule. I think it will be very difficult to renegotiate that part of the convention. And I think it's also important to highlight that the NPFC is not the only one that has such a rule. It's also the WCPFC, and a new agreement on the Central Arctic Ocean also has an invitation by consensus rule. And there are other RFMOs that have a qualified majority voting. So this approval role in RFMOs is not unique. At the same time, the key issue is the application of this rule. And there is large diversity in that regard. So the Commission on the Conservation of Antarctic Marine Living Resources also needs to reach consensus on this, and they have accepted all applications except one. But the WCPFC has rejected all applications except one, and that one is the EU. So I have been involved in the WPFC for many years, and there are quite a number of states that would like to become a member, including El Salvador, Ecuador, and Vietnam. On Russia's reasons, of course, these are set out in Annex E to the report of the 2019 meeting, so you can read this for yourself. I think they are not entirely internally consistent. I think there's some valid points as to the need to conclude a scientific assessment of the chub mackerel stock. But there are also some uncertainties, but I think it's maybe not appropriate that I go into this. There may well be very easy reasons behind this. So in many RFMOs, new entrants find it difficult to become members because the existing members do not want to share the fish with newcomers. I think that's widely known. There was also a question by chat by Mario Aguilar. I presume, Chair, that I can answer that question as well. And this question relates to the reasons for Mexico for not participating in the negotiations on the NPFC. I'm not entirely sure about this. If you look at the map, you will see that there is a gap of the high seas adjacent to the coast of Mexico. So they basically decided to make sure that the boundary of the NPFC convention area would not be immediately adjacent to the Mexican EEZ. Mexico is not a party to the fish stocks agreement. And it's also, for instance, not a member of the Western and Central Pacific Fisheries Commission. And when I worked in that commission, Mexico always had an issue with the high seas boarding and inspection regime. So maybe there are issues, right? Because the NPFC convention is also based on the fish stocks agreement. So there may be linkages there, that Mexico doesn't want to become bound by a convention that is based on the fish stocks agreement. Mexico, of course, is a key player in the IATTC, but I have to be honest that I'm not so familiar with that. I think that's all. Thank you.
Thank you very much. Now, I'm going to invite Professor Antrobas. Please give your ideas on 3 questions from Dr. Lee.
Thank you, Mr. Moderator. I'm very conscious of the time, and I would like first to thank Dr. Lee Ki-beom for his very interesting questions. I will be very brief to address all of them. First of all, what is the, whether or not these measures go further inwards towards the coast, beyond the exclusive economic zone to sovereign areas, for example, the territorial sea and the archipelagic waters, if I recall, that was the first question. Of course, this is only my personal take and view. I will go that far in order to include these areas. First of all, because there is very strict encroachments on this zone, the territorial sea in the UNCLOS. We are not considering here zones of full sovereignty like the territorial sea, but rather zones of where states within the national waters exercise sovereign rights for specific functions. So I will say we should be looking only at the exclusive economic zone and not the territorial sea, although that was an old debate when it came to the negotiation of Article 64 of UNCLOS regarding highly migratory stocks. Nevertheless, that article went only that further in order to impose, as a matter of a pactum de contrahendo, which means that there is an obligation to enter into cooperation and reach a conclusion upon the sovereignty of the coastal state, but nothing beyond that. We have a clear reference to the exclusive economic zone there. And I will say that the same, given the sovereignty and not the nature of the sovereign rights, will apply also to archipelagic waters. By reference to Article 47 in UNCLOS, all the waters which are included landward side of the archipelagic lanes come under the sovereignty of that state. So I will say the same should be avoided as well. And I think you are very correct, nevertheless, to do that remark in view of Indonesia's accession to the Western Central Pacific Fisheries Commission. Now to the second question, of course, what kind of measures the coastal states should actually abide by on the high seas. Let me start by first saying that the very fact that the coastal state adopt measures does not mean ipso facto by the very fact of that situation that these are correct measures. Of course, not, on purpose. For example, we have seen at least two very highlight situations where coastal states have been solely responsible for the collapse of fish stocks within the exclusive economic zone due to their measures. For example, the first it's in the CBT by Indonesia, and also by Canada in NAFO, where it was proved that NAFO was largely responsible for the collapse of some of the stocks, the straddling stocks there. So the question is actually not actually to make a compatibility between necessarily the high C stocks, but to make sure that the measures employed on either side, they are correct. So the question is not actually which measures come first. So there isn't not a chronological order in the sense that if there are pre-agreed measures on the high seas, these measures should be taken into account by the coastal states, but rather whether or not these two measures, these two sets of measures work together. And in that sense, although I have spoken extensively regarding the compatibility rule, we should not actually forget a very important component in that discussion, which is the precautionary principle, which comes side by side with the application of the compatibility principle. Now, in relation to the third question, although I do share with you the love for the textual interpretation and the actual meaning of words, I wouldn't go that far in order to seek the literal or the true meaning of the verb undermine. And most of the academics and the practitioners as well dealing with these areas in the past have, for example, delved into this kind of discussions. For example, there is an ongoing discussion with what is actually the meaning of the modal verbs shall. So in the same approach, I will not go to attest or to find out what is the meaning of the undermine. I will say once again that the precautionary principle should find application alongside the compatibility rule, and any activity taken by the coastal states within the exclusive economic zone should be assessed whether or not, by reference to the precautionary principle, whether or not undermine or they do not undermine the measures taken on the high seas. Thank you.
Thank you very much, Professor Eltobas. Due to the time limitation, I'd like to complete our session 2 at this moment. So Professor Kim and the 3 panelists, you may return to your seat on the floor.
Thank you. Next is wrap-up session for today by Dr. Kim Sung-jin.
Thank you, everybody. Now it's time to wrap up today's conference. First, I would like to express my sincere thanks to all participants attending in this room and joining through Zoom and YouTube lines. To host the conference this year was a new challenge presented by COVID-19 because we could not invite all of you to this conference room. However, thanks to you, we would finish this virtual conference successfully today. I would like to express my sincere appreciation to Minister Moon and President Chang Yong-tae of KMI for their supporting and hosting this valuable conference. Additionally, I would like to thank 6 VIPs for their sending us congratulatory remarks via pre-recorded videos. Moreover, thank you all the speakers and panelists of each session and the participant joining through the Zoom and YouTube Live. Last but not least, I would like to extend my sincere gratitude to all KMI staffers for their dedicated efforts in order to make a more effective and successful conference today. Now, I want to summarize discussion conducted in each session of the conference today. Firstly, at the keynote speech, President Baek Jin-hyun of ITROS explained how ITROS works to cope with the COVID-19 pandemic to overcome the challenges presented by COVID-19. He emphasized the deepest understanding of each other and cooperation among people in ITROS and between the parties of the dispute cases. At the special session, we discussed about the role of law of the sea and its experts in global ocean governance. Professors Rothwell and Kraska presented the great experts of the law of the sea influence on the international ocean order. And Professor Keung-Kwan Lee made a presentation about the importance of the law of the sea and its experts in Korea. He explained the current poor situation of law of the sea experts in Korea, and then suggested several ideas for the capacity building of them. Discussions also suggested various ways to train the law of the sea experts in Korea and global. At the session 1, we discussed recent issues in the outcontinental shelf and the area. Dr. Rajan presented natural resource of the continental shelf beyond 200 miles. And he emphasized in the presentation that resource exploration and exploration can seriously impact the seabed, the water column, and the biota, and so on. Next, Dr. Kallela made a presentation about the development of CLCS, Annex 2 to the UNCLOS in historical perspective. Also, Professor Goulet presented about the works of ISA. His presentation focused on environmental issues rising from the development of the seabed, and he concluded that the ISA process in competing interests between the development and environmental protections is comprehensive, inclusive, and transparent. We just finished session 2, so I think we can skip the summary of session 2. Dear distinguished participants, the goal of the Global Ocean Regime Conference is to contribute a peaceful global ocean governance through a close networking and familiar interaction among the experts in ocean affairs. It was a big challenge to achieve this goal this year because we cannot invite you to this beautiful city in Busan and talk with each other in person. I believe that the situation would not be much different from today, even after the COVID-19. At the same time, we recognize that there are many merits in virtual conference because we can share the conference with much more people without limitations of time and place. Thus, we are going to reinforce the confidence from both offline and online to interact with more people. I hope we all overcome COVID-19 challenges and see you in Korea next year. I would like to conclude this conference by wishing you good luck and staying healthy and safe. Enjoy remaining days here in Busan. And all participants from abroad, I wish for your happiness, healthy, and bright future. And see you in Korea next year. Good night and good afternoon.
Thank you. Now we have reached the end of today's program. Ladies and gentlemen, we thank you for your presence and participation. Thank you very much and goodbye. 네, 저녁 식사 안내해 드리겠습니다.